who is joining from Ahmedabad on the topic of drafting of deed, documentation and its legal importance. Welcome to Hyderabad, sir. I welcome respected Chairman of Hyderabad Branch, CA Machara Minavalli, past Chairman CA Vayu Banarendra Garu, Vice Chairman of SIRC of ICA CA Chinnamastan Talakaila, Central Council Member from Hyderabad CA Dayanava Sharma. Welcome all the members and once again everyone, welcome everyone. I request CA Machara Minavalli to give overview of the 4-day workshop on today's topic, please.
Thank you, Secretary sir. Respected Central Council Member Dayanava Sharma ji and Vice Chairman of SIRC Chinnamastan Talakaila sir, and Land Speaker of the Day, Advocate Vishal Dev, and our Senior Bonu Narendra Survey, and our colleagues Satish Kumar, and senior members and delegates. Warm welcome to this 4 days webinar on drafting and representation before authorities. Members, really it is one of the dream programs of mine, and I requested entire managing committee almost 6 months back. Based on entire support from the managing committee, we could able to arrange, particularly with the help of Nipin Shangviji from Ahmedabad and Vishal Dev from Ahmedabad. And first and foremost, and I would like to thank all the land speakers who has consented to be deliver on various topics at the sessions for the next 4 days. We have been facing various authorities with respect to various optional matters, and presentation before authorities is of utmost importance for our profession. It was hence felt by us the need of this program, especially in a drafting and representation before authorities, so as to refine our drafting and representation skills, particularly after initiation by the government on faceless assessments. This program will be focusing on various aspects of general principles of drafting, guidelines for use of particular words and phrases for drafting and conveyancing. Drafting as such demands a lot of skill combined with our patience. A properly drafted document aims at accuracy and truth, and it should speak the mind and intention of the draftsman. The importance of the documentation, and before using any words or terminology in the document also very much important. As a chartered accountant or as a professionals, we should understand the legal language and legal terminology of the document. That is one of the main intention for organizing this entire webinar. A clear presentation is essential for requirement for clear thinking. The style of language should be simple and at most appropriate use of legal terms that would convey the facts in the precise and simple manner. This workshop will also focus on how to make effective research of income tax case laws, and in the 4th day of this webinar, Ari Agarwal sir is going to take on research of the case laws and how to use the case laws before representing the authorities of the Income Tax Act, and how to appear before NCLT and NCLAT, and how to present before NCLT and NCLT. The land speaker from Ahmedabad, CA Advocate Nipin Shangviji, is taking the tomorrow on 2nd day of this webinar. And the third day, the art of representation is maybe before income tax authorities or GST authorities. Art of representation is going to take by our senior speaker, CT Bonu Narendra sir from Chennai, sorry, CA Bonu Shekhar from Chennai. So these 4 speakers are going to take 4 days webinar, particularly the aiming for drafting and representation before various authorities, not only income tax, not only GST, not only NCLT, it may be before companies as per Companies Act 2013, or it may be before CPE, etc. That's what, as a managing committee, with the help of our regional council members and central council members, we decided to organize this drafting and representation course. And I once again thank all the land speakers for accepting and joining to share their expertise and experience in the 4 days. And also thank all the delegates who are registered for the virtual program. I wish you happy learning. Thank you so much. Over to Secretary.
Thank you, Chairman sir.
Yeah.
Now I request SIRC Vice Chairman CA Chinnamastan Talakaila to address the members, please.
Thank you, Satish. Our respected dynamic Central Council member from our Hyderabad city, Dayanava Sharma ji, Chairman of Hyderabad branch, Machara Minavalli, Speaker of the session, Advocate Vishal Dev, and Secretary Satish Mailavarpu, past chairman in the committee, Bonu Narendra, past chairmen of the branch, past council members, and other professional colleague joined for this virtual CPE webinar series covering the issues of drafting and representation matters before the different authorities. A very good evening to one and all. First of all, I need to congratulate the efforts of the Hyderabad branch for the completing successful special drive for vaccinating the members and their family in around the Hyderabad for 3 days at our Center of Excellence. At these days, when there are numerous scarcity of the vaccination, providing the vaccination to the members on priority is a wonderful task. I really appreciate the entire committee and including our Honorable Central Council members. In addition to taking these steps forward, I request the Hyderabad branch team to look the possibility of conducting one more special drive for the office staffs and the students, as there are several requests from the students as well as the principals as members who are working with the staff. Members, though the drafting of letters and representation before the different authorities is not new to our chartered opponents, the drafting has gained importance at a time when the faceless assessment were started by the income tax department. Whatever we wanted to communicate the assessing officers, we had no other option other than through our legal drafting skills. It's very hard to share that looking at the present scenario, we has to equip with our better legal drafting skills as to compare the previous or past practicing days. At present, in few of the partnership firms, we can see the tax partners, audit and assurance partner, GST partners like that. I'm sure next 2 to 3 years, firm must have at least one legal drafting skill partner to represent and submit various matters before the different authorities. Every child opponents and the students, including the article students, should made to understand the importance of the letter writing and the protocol at various authorities, how we best need to present our case before the various departments and authorities. Besides being we academically and technically, we are very strong unless we are good at representing skills before the authorities, we are not full-fledged still persons. I believe this kind of session by experienced members and members from the other professions would definitely enrich our fraternity. I really appreciate the efforts of the Hyderabad branch and thank the experienced professionals who would sharing their thoughts with our members in the coming sessions. Thank you, each one of you. All the best. Stay at home and office. Stay safe. Thank you so much.
Thank you, Chinmastan sir. Now I
Thank you.
request.
Yeah,
CA
please there is.
Now I request CA Dayaneva Sharma, Central Council member from Hyderabad, to address the delegates, please.
Thank you, Secretary. Respected Vice Chairman of the region, CA Chinnamastan Talakaila, very nice words of wisdom you have spoken about, and very interestingly you have put forward your views. Compliments, and really thank you that you put it in a right perspective. And more importantly, I join Chinnamastan in complimenting the branch for doing the entire vaccination drive of 1,400 members and their family members at one go, which is something which we all are really proud about. And whatever support, whether it is Central Council member or Regional Council member, it is always available to you, Chairman. Compliments to you. Really good initiative to take this 4 days course very effectively, positively on this drafting matter. Excellent. Compliments to you and your team. And Banu sir, who can be a better person than you, who is actually representing in the different forums qualitatively from the next generation, My father generation, Kalyan Das Saab, Devi Das Saab, we have seen them representing before the tribunal, Srinivas Ayadevra sir. But from the next level, you are the person who are actually holding that fort very strong, and really compliments to you to ensure that the branch is moving towards the right direction. And Satish, good job every time. And Vishalji, I can only tell you is this is your hometown. You play well. That's the only thing. You are playing on a home turf.
Yes,
So
yes,
don't
yes.
bother about it. And welcome to you. We have very fascinating memories of Ahmedabad, always coming and talking in Hyderabad. And we
Yes.
have always a fear of myself, if he comes here, what will happen to me? So I can request you to continue that that point very strong. But friends, one thing I would like to tell you all is, the topic which has been taken with regards to drafting and representation before authorities. There are three aspects to it. The first aspect is a written representation which doesn't see your face, but only the English which is written is going as a communication, and you need to express within the less words best possible way. So that is a written representation. Number two is physical representation. If just imagine whatever I have drafted well, might be I will not be a person, my partner might have drafted it well, but I might not be a drafting expert, but I might have a partner in my firm who is actually a representation expert. So that means a person who's going to appear before authority will be holding the entire firm strong and the client strong on behalf of each one of us. And the third one is the presentation skill. What I mean by that is, I am wearing a shirt without tie versus my vice chairman wearing a coat with tie. It makes whole lot. Mastan, we are able to see your tie, you are shaking your camera, I can understand. But that is also one of the most important part. Communication, representation, and presentation. There are three aspects in making it a fine, case before any authority. And the moment you stand up as a professional, I think the language written in the paper, the way you talk, and the way you present will make whole lot of difference. And that is how the highest paid advocates are being paid across the length and breadth of the country and the world as such. Rightly said by Mastan again, when you are talking about a representation which is faceless, I would like to tell one thing, which is very, very important to be understood by each one of us, that today, the appearance is not a criteria anymore. It's basically what you put on the paper will matter a lot. And that is how the faceless is going to move towards. There is a probability that we might be good in subject, we might be understanding its subject, but might be today is time where we need to think about the peer growth, cross-selling each other. Might be a person is good in one thing, I might be good in another thing. And today it is time to collaborate and make things happen very qualitatively. That is the most crucial things. Because of only one reason, Vishalji, you will agree. In the court of law, when you stand, you are having eye-to-eye contact with the judge. When I am representing before the ITAT, I have eye-to-eye contact with the bench member. When I am representing before an assessing officer, he also has eye-to-eye contact. He means those people have little regard to sentiments.
Yes.
Little regard to sentiments. But when it is going to be a matter of computer doesn't have sentiments at all.
True.
And that is how the notices are being shared, sent to all our SSC, left, right, and center. Everyone is breaking their head from where these notices come. He didn't understand, because system doesn't have to understand.
Understand.
It doesn't have any sentiments. It is ruthless. I'll put the word, it's ruthless. It will calculate your tax liability and penalty and just send a mail to you saying that, boss, thank you very much. You have defaulted by 1 day, 1 year, 1 month, 18 days, 21 days, whatever that calculation is. And it is going to say, I'll not accept your return. I'll not accept your return till the time you pay this amount. 0.89 paisa also have to be paid by you. That means they don't have sentiment, they are ruthless. Now the point has come, when you want to fight back with regards to this kind of environment, the most important part is how you represent your matter. We need to explain our client. Client has to understand, then the representation has to go. And multiple things are undergoing to go change. This profession, as I always say, was relevant yesterday, will be relevant today, and will also be relevant tomorrow. But only thing is, yes, we need to adapt for that kind of changes, which is expected. And you also equally have to become ruthless to talk to client. I'm putting in a positive sense. Bhai, iske baad, I cannot help. This is what the system is asking. 7th July, new income tax website has come up. It is putting circles and circles and circles. But yes, they are going to come out with one of the finest site where your data will be auto-populated from all the sections of your life, and that will be given to you for review, and just edit with explanation and put push button. That's it. And your new income tax return in the new site will be linked, where it is a tax audit case, will be linked with your income, chartered accountants, FRN number, MRN number, and everything. So just imagine this entire thing is going to be on a total different note. And I look forward, let us start working towards two things. Either I know, or I know who know. Either you know, or you know who know. I might be fantastic with my client relationship, but might be when it is required for time where we need to go for representation, we have to catch people like Bhanu Narayan Rao who are drafting multiple cases. Bhanu sir, I am marketing for you. Okay. So the point is, it is time where we need to come together and make it happen. Yes, but it doesn't stop us. Certain things we need to start from scratch. Certain things we need to, rewind and move forward. This is a very good move this department, this branch has done. Majan, compliments to you and your entire team. Thank you all. Thank you very much.
Thank you, sir. Thank you.
Thank you, Daya sir, for your opening remarks.
Satish,
Yeah.
Satish, one important thing. And I thank Vice Chairman SIRC and Chairman Central Council Member Dayana Sharmaji for their valuable words and words of wisdom. Sure, sir. We'll start from this. Actually, this is the basic webinar, basic program what we have planned for 4 days. First thing is today we are discussing about documentation, legal words, and what's important. And second day is we are talking about before representation before NCLT. Third day and fourth day we are talking about order of representation and income tax representation before authorities. Once we have done this program, and additionally next level program also we are planning, sir, with the help of Nipun Sangviji, where we can plan again 4 days, which representation before as per the Companies Act 2013, CPE and authorities. So we are also thinking about that as one advanced level program. And this is for your information, Dayana Sharmaji. And Mastan sir, thanks for your compliments, Dayana sir, thanks for your compliments for conducting 3 days vaccination drive. Literally, I thank each and every member who has come there and supported. And a special thanks to the entire team of Managing Committee of Hyderabad branch. And I take a chance to express my gratitude to my entire team, Bhanu sir, Pankaj sir, Satish, Deepa, KGS, everybody literally, they stand there as a frontline workers. Really, they stand there frontline workers for 3 days and supported entire 1400 members. And I really thank for their support, including Central Council member and Regional Council member. And yes, sir, Mastan sir, we are planning for one more drive based on the request from the members. And over to Secretary.
Thank you, Chairman sir. Now I request past Chairman of Hyderabad branch, CA Vaidi Banarendra Garu, to introduce today's speaker, Advocate Vishal Singh sir.
Thank you, Satish ji. Chairman of Hyderabad branch, Macharao ji, Central Council member from Hyderabad, Dayanivas ji, and Vice Chairman of SIRC, Chinamastan, and other dignitaries on the screen, and my dear delegates. Today we have with us a very young and accomplished lawyer who was appointed as the youngest assistant government pleader before the High Court of Gujarat. He dealt with extensive litigation practice across various laws such as criminal, civil, and commercial cases, and also constitutional writs involving complex issues and questions of law. He also argued and represented it in various public interest litigation and constitutional challenge to law. He appears before the National Company Law Tribunal and the National Company Law Appellate Tribunal regularly and has dealt with IBC cases. He is a regular faculty, a regular speaker, and panelist across various forums, conferences, and media. Many cases that he has represented have been regularly reported by the print, electronic media, and the web portals. He is a practicing advocate before high courts, the lower courts, and various tribunals, as already stated. And today he has come to his Nani's place, and he is going to be as mischievous as possible while dealing with the subject. Not only mischievous, he is going to be very strong, and he is going to put the words straight across on how to increase our skills. He is also going to tell us some differences about what is the difference between a deed, a document, an MOU, a conveyance deed, a sale deed, all such things. Some of us know, but I think we do get confused. And he's none other than Advocate Vishal Jyotish Kumar Daveji from Ahmedabad. And thanks to Chairman, we are having direct flights connecting flights direct from Ahmedabad and Hyderabad these days. And Daveji is come today on one of such flights. And we are very fortunate to have such a young, energetic, dynamic, and accomplished lawyer who is going to speak to us and enlighten us. Over to you, speaker, sir.
Thank you, Banu sir.
Thank.
Vishal sir, please take over.
Yes. I really thank to all the respected dignitaries for giving such a wonderful opportunity before such a very intellectual people there. So I'll try my level best. Whatever experience I have gathered in my litigation days, since starting of my career as a lawyer, my father was a senior criminal lawyer. My uncle was a retired Chief Justice of Gujarat High Court. So I have seen in a family of lawyers. So from the very first day, I entered a litigation room. So because as a Central Council member very rightly says, when you appear before a forum, when you argue a matter before any tribunal or a court of law, you get very fraction of second to represent your case, right? Because you may have 10 points to argue, but you have to be very selective that which point to be hitted to the judge. And very well, before you start your argument, you need to know the judge also very well, that what is his mindset, So before appearing, we always do a basic research of his earlier judgments, that what way of the appreciation of his intellectual would be, and how the judge would tilt around it. So this is how I have seen around, appearing before many senior advocates also, and how they, take hostage of the entire proceedings. And so this all comes from the experiences. And as many of the members said, that representation is very important. How much to speak, when to speak, because and how to counter it, and what would be the you need to have a brainstorming exercise before you enter the courtroom and put your strongest point. And sometimes what happens, just within one submission, your entire case goes turn around. So this is how it happens. And why drafting is more important, as rightly said, because some judges are very intellectual, they come very prepared, and they don't give any room of argument, and just throw one or two questions just before you open your brief. So if you are able to satisfy that one or two queries of the judges, then you are succeed. And similarly, any relief or maybe notice has been issued. So this is at every level, because now we have seen that cases are very piled up. So now adjudication process has become very fast. So that lengthy argument has shrunk, and you get very very little time to respond to any of the queries of the judges. So drafting is very important. So if a petition is very well drafted, 50% of the job is done. And suppose sometimes some judges are like they don't read actually. So you have to be a very good storyteller. So you have to start telling the story from the facts, And what happens that, there are two aspects. One is a question of law and question of fact. So what many professionals do, they did a lot of judgments and they have very proficiency on the law. But what I experience is that you have to be strong on facts, because facts come first and the law comes second. So whenever a brief is to be open, judges will say, what is your facts? So what some professionals do, that they start arguing on the law point and the section, but the judge gets very annoyed, because they have to deal with a lot of cases and they are always under pressures. So sometimes you have to see the time set also, and sometimes if you see that earlier a case has been spoiled and the judge is not in a mood, so you better avoid your proceedings. So this is a very spontaneous things you have to do during the course of the practice, which I have developed, at various forums. And how the trial also, I've dealt in the trial court cases also, of leading of evidence, which I think as a CA professional also, that part is would be missing. So appreciation of evidence is also very important once you go in the drafting aspect, which today in my seminar I will deal with it. Some evidence sections of the Evidence Act, which is very important for a professionals to understand it. So this is the gist which I have dealt with. So if we can begin our presentation.
Please, sir, you can start.
So can you make me host? So I will just.
Yeah, done, sir.
Yeah.
Pankaj, sir, good evening.
I think he's the host. No?
Yeah,
he can do this.
Yeah, you can do, sir.
1 second.
You can do.
So can you see, sir, my presentation?
Yeah.
Yes.
I'm sorry. This. One second. So it is visible, sir?
Yes, sir.
Yes, sir.
And I am audible to everyone?
Yes, done, sir.
So today I'll begin with my topic is drafting of deed and documentation. So as I said in a brief, drafting is a very important aspect for every professional. So now the dynamics of the every professional has changed from the appearance before the tribunal. Now we have due diligence, consultancy, and if we practice across IBC during the entire resolution process, we have many aspects of consultancy, due diligence, and legal opinion. Because since whenever there is a law which is evolving law, where the jurisprudence is not settled, there is very big opportunity for professionals from the consultancy and the due diligence and appearance point of view. So today in my presentation, I'll deal with the basic principles of the drafting part. Then I'll deal with some of the section of the Evidence Act that will focus on the evidence part. And lastly, I will share one drafting aspect of the legal opinion, that how the legal opinion has to be drafted. So first, if we start from the basic thing, that what is document? So if we see the basic definition, a document is something that furnish evidence and shall also include matter written, expressed, or describes upon any substance by means of letters, figures, or marks, or by more than one of those means, which is intended to be used or which may be used for the purpose of recording that matter. So in legal terminology, documents, something which is in written form, have some evidentiary value. So if we prepare any document, or if we prepare any deed, or maybe any pleading, which have a evidentiary value, so in legal terminology, that thing according to us is the definition of the document. So now every act has a different set of definition of the document. Now, as you see, first definition is from the General Clauses Act, which gives a very basic definition of the document, which is something having a evidentiary value. So this is why I am focusing on the evidentiary value, because whatever document you create, that will be after implementation, or maybe any disputes which arises based on that document, or maybe a contract, then that document will be tested in a court of law once the dispute arises, right? So that is the reason that document have a very evidentiary value as far as the touchstone of the interpretation of the law is concerned. So General Clauses Act will have a definition. Now General Clauses Act is very important as far as any definition part is concerned. Sometimes what happens, that in any act, if you see the definition sections in the act, some definition will, or some word will not be defined. In that case, you have to refer General Clauses Act. So very important, this General Clauses Act is very important as a practicing point of view. So if you don't find any definition of any word in any parent act, then you can take a shelter of the General Clauses Act. Now, if you see the Companies Act, Section 2, document includes summons, notices, requisition order, other legal processes and registers which whether issued. So as per the Companies Act, a summons notice is also regarded as a document. Similarly, now as per Evidence Act, Section 3, document denotes any matter expressed upon substance so intended to be used or which may be used as evidence of that matter. So what Evidence Act says, that if you have any document which intended or which may be used for the purpose of evidence, that what defines the Section 3 of the Indian Evidence Act. So again, as I said, every document you prepared or draft must contain the evidentiary value. Similarly, as per the IT Act, if you see, the document defines electronic record. So nowadays, if you see, everything is we share on an electronic medium. So even the whatever email or whatever document you share through electronic medium is also regarded as a document, and that carries a evidentiary value. So whenever if you have anything which you put on record as an evidence, even before a court of law, which is in the electronic record or electronic form, right? So that is also a document and which have some evidentiary value. So nowadays the court are recognizing any document which is in electronic record as a document as per the IT Act, and it has some evidentiary value, which in my next coming slide I'll take that how in a court of law the electronic record is regarded as a document and how it has to be interpreted as an evidence before the any forum. Now, if you see, as per the Registration Act, Section 50, document means a document which is legally enforceable. So now some documents has to be legally enforceable. Otherwise, that document will not have any evidentiary value. So we have to see that per the Registration Act, for example, sale deed, mortgage deed, or some type of deed, which is compulsory to be registered as per the Registration Act. Now, if you don't give that effect to that document, right? And if you don't register it, if it is mandatory as per the Registration Act, then that document would be void or defective in nature, and that document would not be enforceable. In many cases, I have come across in DRT and many cases where the documentation of the loan transaction, such as the title document or the mortgage document, are defective in nature, whether because that document are not properly registered. And if you are not registered, proper charge is not created, right? And futurely, when the financial institution enforce their right based on that document, then it comes to know that that document is properly not registered and defective in nature. So these are the legal issues which come arises if your document, which is compulsory to be registered, right? And if you not registered it. So this was the some of the basic definitions that every act will have his own meaning of documentation, right? So these are the some of the things which I have taken it. Now, drafting, pleading, and convincing, right? So there are three aspects to drafting. One is the drafting part, second is the pleading, and third is the convincing. So all the three processes which we undertaken in which we created document. Now, drafting, we have agreements arising out of the contracts. So in day out, as a professional, we draft many agreements, many contracts, many MOU, that is memorandum of understanding. So every agreement contract or MOU will have a different set of legal consequences, right? Which in my next presentation, I will deal with it, that agreements, contracts and MOU, what is the basic difference, or deed, conveyance deed we say, and what are the legal issues arises with those aspect of the drafting. Second, we have pleadings, formal statement of cause of action or defense. So what is pleadings is whatever pleadings you draft before any forum or tribunal or a court of law, right? That is also one nature of document. So pleadings part is very important. So there are normally three types of pleadings which I would divide. One is the civil pleadings that normally we undertake before a tribunal, quasi judicial authority, or maybe a court of law. Second, we have a criminal pleadings like a bail application, caution petition, or maybe FIR. These are the basic criminal pleadings. And third is the writ petition. So writ petition is directly a constitutional writ which we file before the High Court and the Supreme Court, where the Article 226, 32 we invoke. Normally, whenever we challenge any constitutional validity of any law, where virus of law is challenged, then it has to be tested under the constitutional validity for the High Court and the Supreme Court. So there we file a writ petition. Third aspect is convincing. Convincing is like where you from one legal right to another legal right, you transfer any title or right. So normally in conveyance we have a sale deed, very partnership deed, all the types of deed where your rights and liabilities are defined, and one on based on that conveyancing you're transferring one title or any specific right to the second party. So now what are the professional opportunities? Look a subject from global perspective. So as I said, because of the new law in force, right? Global perspectives, drafting is very important thing. Consultation and legal opinion. So as I said, now since because IBC a very long resolution process at every stage, we have to give legal opinion based on which the committee of creditors or maybe a resolution applicant or maybe a resolution professional will take a conscious decisions on the entire procedural aspect. So drafting of various documents, as a professional we have a very a new arena of drafting various type of documents, starting from the contractual documents or maybe another set of documents or maybe a loan documents. So these are the other professional opportunities. Vetting of drafted documents, now this is again a very important aspect. Normally we get a very cream of work where we have to vet the document, and after vetting we have to say our client that what are the clauses which are to be removed and what are the clauses which have to be incorporated with the new amendment under the law, so that after vetting the document becomes a very precise thing and we can protect our client rights and liabilities based on the transaction he would be entering upon. Now with modification, due diligence, we everyone know, limitation, claim filing, other drafting opportunities are also there in another field of area. So we have ample opportunities as far as the drafting part is concerned. So before we start drafting, right? So what we see that once any drafting comes to us for any specific query, first we need to jot down as a professional that what are the acts basically would be applicable to us. So ultimately, whenever you draft any document, whether it is an agreement, whether it is a contract, whether it is a pleading, or it is a legal opinion, generally as a draftsman we have to give a 360-degree approach to our drafting, right? So normally many things which I have experiences that we always look only from the one perspective. For example, if you want to draft a document or an agreement, we always see the contract act, right? But apart from the contract act, if you have to see that who are the two parties who are coming to contract, suppose if the two entities are the companies who are entering into a contract, then we have to see that the Companies Act will also be applicable. If there is one partnership firm and a company are coming into a contractual arrangement, then the Partnership Act will also be applicable. So we have to see from we have to jot down that which would be the laws or prospective law or act will be applicable before you draft any document, right? So this is a basic thing, and we should make it a practice that once we any subject matter we are preparing it, you have to jot down that yes, 1, 2, 3, these are the basic prospective document law, or maybe the act will be applicable. So that why it is so important that once you prepare any document, right, then you cover the entire aspect. So legally, one thing will not be left out, so that suppose in future when that document is implemented, or maybe a dispute arises, then you have covered almost all the legal aspect, covering whatever the laws which be applicable in that the entire document. So we have a Indian Contract Act. These are basic general principles of contract. We have to remember it whenever we prepare an agreement, MOU, guarantee, power of attorney, or any other specific document covered elsewhere. So Indian Contract Act is very important. General principle of contracts we have to offer, acceptance, everything we have to remember, consideration, right? So whenever you prepare an agreement or contract, uh, this Contract Act general principle of contract has to be there in mind. Then we have a Companies Act. We have a memorandum, article of association, resolution, minutes of meetings, scheme of amalgamation, demergers, connected document. So under the Companies Act also, we have a lot of drafting of this entire MOU and association resolution. So whenever you prepare any document under the Companies Act, then the provision of the Companies Act has to be very important, and we have to remember the basic interpretation and basic things that in a document preparing under the Companies Act, or maybe in the contract, or general principles has to be bear in mind, so that tomorrow if that document is challenged legally, then there should not be any window of interpretation which will be left out. Similarly, if you see the Indian Partnership Act, we have to generally draft partnership deed, reconstitution, resolution, retirement of partners. Now, if you see the Transfer of Property Act, we have a sale deed, lease deed, gift deed, exchange of property, mortgage document, agreement of sale, construction development agreement, and release deed. So these are the nature of document that covers under the Transfer of Property Act. Now, if you see under the Transfer of Property Act, if you have a drafting of any lease or rent agreement, right, then or a mortgage document or agreement to sale. Now, these are the very common nature of document you draft under the Transfer of Property Act. So we have to see. Then I'll in my next presentation I will say that in lease agreement, or maybe an lease agreement of long nature, where property has to be leased out, or for example agreement to sale transaction where you have to sell the document, right? So in that nature of document you can have a clause of arbitration. So what will happen if you have an arbitration clause? Then you are adhering to the alternate dispute resolution mechanism. So you are coming out of the clutches of the another court of law. Otherwise, what will happen when there is a dispute under the lease or the agreement to sale disputes? Then normally you have to approach the civil court for the specific performance. You have to file suit for specific performance, or you have to file a lease agreement for enforcement of any eviction suit. So that is a very cumbersome process. So if you have a knowledge of arbitration clause, and if you describe the arbitration clause in all such agreements, then that is a very fast remedy. It is an alternate dispute resolution remedy, and this is how you can save the client from going to a civil court, where the litigation, we know that in a civil nature of litigation takes long number of years for adjudication. So now we have intellectual property rights, copyright, relinquishment of copyright, trademark, assignment, patent. So under the IPR also, these are the nature of documents which normally, whenever you have a licensing agreement of any technology, for example, any thing, companies like IT or the uh, pharma companies, if you see, their main asset is the IPR, right? So in that also, this type of agreements are very much is drafted so that their IPR is protected, so that which is the basic important assets. Now, if you see the basic banking transaction, we have sanction letters, board resolution, hypothecation, and mortgage documents, which I earlier said. In many cases, we come around that there are defects in drafting of such documents, which further, because if a loan transaction having a huge lending, then as I practice more on the defaulter side, right? So we have to find the lacuna, that which are the document is void or which are the defective document, so that if such defense are raised, then the adjudication will take a very long process. Now, if you see the industrial and labor laws, we have appointment, apprenticeship, discipline proceeding, charge sheet. So now the labor laws are very important. Under that, these are the type of documents which normally we need to be drafted. Insurance laws, also insurance policy, assignment, and other connected documents. Now, if you see the arbitration law, which I was talking about, arbitration agreement, international arbitration agreement, notices for arbitration, submission before arbitrators, proceedings for challenge. So arbitration laws is a very important law, and we have to be very careful when we draft any arbitration clause, right? And once we invoke the arbitration law clause, once the dispute arises, so we have a dispute resolution clause under the any agreement you draft. There has to be a specific dispute resolution clause. In many agreements and contracts which I have vetted, I have seen that the draftmen omit the dispute resolution clause, or maybe that dispute resolution clause is not at all specific. So what happens that once there is a dispute, you don't know whether you have to give a notice or we have to invoke an arbitration clause, or before invoking, what are the things you need to take care. So dispute resolution clause is very important. Uh, Arbitration laws, why important? Because if you want to have an alternate dispute resolution mechanism which is more effective now, since there are amendment to arbitration law also, right? So very fast adjudication take place compared to if you go to a civil court, right, which takes a long adjudication process. So arbitration laws are very important in day-to-day drafting of any document. We have international agreements also, agreement between the parties, corporates having different nationalities. So whenever if you come across having a international agreement where the cross-border transactions are there, then we have to be very careful, because something which is legal in our country may not be legal in another country, right? So there would be a vice versa. So whenever you come across any cross-border transaction, make sure that you have to study the laws of the other country also. You have to study the treaties and the protocols and conventions which would govern the situation. Because what happens in many international agreements, because see, this all dispute comes once there is a dispute arises, and based on that agreement, when there is a litigation, or when we have a when we appear before a court of law, so this all interpretation comes into picture, right? Once there is no dispute, the agreement is fine enough. So that is what we are saying, because in many agreement which I have come across, something in cross-border transaction, something which is legal in India is not permissible legally in another country, right? And something which is legal in that country is illegal in our country, right? So we have for that aspect, we have to be very careful once we come across into cross-border transactions. So we have a testamentary and family laws. So nowadays, because of this COVID situation, we know that many unfortunate death take place, right? So now this has also opened a very broad aspect of drafting of will, cancellation of will, family settlement, creation of trust, family partition, marriage and divorce. Because now what happens that many NRI, they have a very huge investment here in India, or many big families also have investment. So they are worried about, because of this COVID situation, we don't know what will the life will be all about. So now this arena is also open up. People wants to know that how to prepare a will and how to settle their own assets, so that in future there may not be dispute amongst their legal heirs, right? Or maybe suppose if a husband and a wife, they also want to be financially secure, so that maybe there may not be dispute after they expire on their succession on the such issues. So this is also a very important point and aspect. Because of this COVID situation, we have got many clients who want to prepare their will or maybe their settlement agreement in advance, so that in future they can avoid such situations. So now we have other financial transactions also, like we have commercial papers, related documents. So this is also one nature of drafting which we have. Other miscellaneous documents is like formation of societies, NGOs, Section 25 Companies Act, joint ventures. So nowadays we see that we can also prepare a trust, or maybe a cooperative society. So there also professional have to draft various bylaws, so that bylaws governs the entire aspect of the maybe a cooperative society or maybe a trust aspect. So that is also one of the arena. So this was the basic thing which we say that under this law, these types of documents normally which we come across. Now, whenever you start a business contract or whenever you start drafting, right? So these are the 5 stages which I have enlisted here, which says if we adopt this approach according to my this experiences which I have derived it, then the document which you prepared at the end of it will be very perfect, will have minimum legal complications, and once it is implemented or maybe any dispute arises, then we have a very good legal chances succeeding in the court of law, right? So as I said earlier, why drafting aspect is very important, because there are 2 stages. One is the pre-litigation and other is the post-litigation. So whenever drafting of any document which we undertake, once any comes into the post-litigation stage, right, then we lawyers or we professionals try to find out the lacuna in the document, right? Because in contractual disputes, you cannot go beyond the contract, right? So whenever there is a contractual disputes, we have to cover, you have to play within the pleadings of the contract, right? So we have to find out that which are the clauses are illegal or which are the clauses is not, their interpretation is not in accordance with law. So this is how we have to defend it. Now we have 5 stages which I have enlisted. One is the negotiation, second is the drafting, third is the stamping, fourth is the execution, and fifth is the registration. So whenever you come across having any subject matter for the purpose of drafting any document, for example, if you want to have an agreement to be drafted or a contract, then you have to see whether that agreement is creating any consideration thing or is just a basic thing, because there is a difference between an agreement and the MOU, right? Because once if that negotiation part, you have to take an input from client that what are your rights and liabilities and what you are up to. So that is a negotiation. In the negotiation part, what we do, that we sit across the client, we understand the nature of transactions, we understand the right and liabilities which would occur, and then we jot down the laws which would be applicable in the entire nature of transaction, right? And then we can start the basic sketch of a document. So once that negotiation part is done, once you have taken an input from the client and the documents which you required for the purpose of drafting, then your stage 1 is closed. Then comes the stage 2 where your skills will come up, right? That is the drafting part. So once you have the basic input of the nature of transaction, right, you will start drafting the document and you will start explaining the document that what would be the nature of transaction, what is the right and liabilities, and what would be the conclusive part of the dispute resolution process, right? And then the last part. So drafting part would be that in an agreement, you try to sketch down whatever the input which you have gone to protect the nature of transaction of your client's rights and liabilities. So your stage 2 is done. So normally you tend to prepare a two sketch of document. So what I generally do, that whenever I get an input from the stage 1, I prepare a sketch of document, a rough draft. I never finalize. Then I twisely I vet the document from my end, so that every time you vet the document, I'll surely say you that once you start vetting twice or thrice, you will find and you will try to improve the language or maybe some of the points which you might have omitted. So vetting is very important. So your stage 2 is done once you prepare a document and which is incomplete. Third is the stamping part. So some documents which required has to be sufficiently stamped. So you have to refer to the Stamp Act, which normally many drafting document which have come across which are not sufficiently stamped. Even the financial institutions who enter into a various loan and commercial documents, they are not sufficiently stamped. So once the document is not sufficiently stamped, then that document is not legally enforceable. For example, if you are entering to sale deed, and sale deed also you need to be have a sufficient stamp duty, otherwise your document will be impounded by the competent authority, right? So we have an inspector general of stamp who is responsible for seeing that your document is sufficiently stamped or not. If it is not sufficiently stamped, then it will be a defective document. So stage 3 is stamping of document is very important. So you have to see whether your document which you have prepared is required to be stamped or not. Stage 4 is execution. So once your stamping is done and you have properly stamped sufficient stamp on your document, then execution part comes. So in execution part is very important that which two parties are into execution. For example, if one party is company and company is represented by director, then the copy of board resolution is very important to be annexed. In many cases we have come across in the contractual disputes that normally if a company is a party to a contract and where any authorized representative has executed the part of a contract, the first nature of dispute we say that the person was not competent or properly had the authority to do the execution of a contract. This is the very basic defense normally has been raised in a contractual dispute. So execution is very important. So what I advise my client, whenever you prepare a document, the board resolution copy, or you have to mention that so and so authorized person is being authorized by way of a board resolution so and so, right? And a copy is to be annexed at the time of execution of the document. If it is in case of a firm, partnership firm, then the authority letter has to be annexed, right? So execution part is very important, and from which authority you derive to execute that particular document, right? So execution part is very important. And last stage is registration. So as I said, the registration act is there. So you have to see whether your document has to be registered or not. Some documents are required as per the registration act. Some documents are not required to be compulsory registered, right? For I'll give you one example. If you prepare a will is not compulsory to be required to be registered as per registration act. But if you registered it, right, then the evidentiary value of that will be increased. So in future, if when you enforce that will, right, and if it is properly registered, then the evidentiary value will increase. So because of that, you have a very good chances of succeeding in a litigation process. So these were the 5 stages which I have enlisted once the document. Now I will say that common features of a document. Now every document, if you prepare, right, will have some common features. So these are the some common features which I have listed here, which has to be there in your document, so that your document will be a very clear and very easily readable, and everything has to be in precise chronology. So first feature would be commencement and title of the document. So as you say, whenever you prepare a document, you have to give a title, whether it is a deed or maybe an agreement or a contract or maybe a memorandum of understanding or mortgage document, whatever it is. So title is very important, right? So in many cases, what happens that title may not go with the part of the pleading. So whenever an interpretation part is concerned, title is not important. The content of the document is important, because the content will give the actual picture of the rights and liabilities or or which right has been created. But then also generally we have to define that what is the nature of title of the document. Now second what part in a document feature would be a description of parties, right? So in many documents I have come across that description of parties is not elaborated, right? So we have to describe what are the parties would be, whether it is a company, whether it is a firm or a proprietorship, whatever it would be. So description of parties is very important, and their legal character. For example, if you have a company, right, or maybe then we have to say that the so XYZ Private Limited is a company incorporated under the provisions of Companies Act. If you have a firm, then you have to define that XYZ is a firm duly registered under the provision of the Partnership Act, or maybe LLP. So the character is very important to define, right? So this is the second important thing. Common feature has to be there. Third is the recitals. Now what is recitals? Usually it begins with the word whereas. and it controls and narrates the background of the operative part of the document. It may narrate the circumstances, context in which the document is to be prepared. So recital is in a document is shows your mirror image that what would be the nature of transaction would be there. For example, if you are entering into a loan transaction, right, then the recital would start showing that who is the borrower, who is the lender, right? If you are entering into in a, for example, a rent agreement or lease agreement, the lessee and lessor would be there. So recital will start with various which shows the nature of transaction will be defined, that your document will contain what nature of transaction in the entire area. So after the recitals is done, we have a parcels of clauses. A phrase from English drafting, which is popularly used, refers to property sought to be conveyed and correct descriptions thereof. So this parcel is like, for example, in a conveyance transaction, for example, in a sale deed, right, where or for example, an agreement to sale, where or in any nature of transaction where a property has to be transferred, right? So in such type of document, we have to clearly describe the nature of property, right? For example, in a sale deed, if you see, we have a schedule. Normally in the first part of agreement, entire narrative of the immobile property will be explained in the schedule, right? So schedule has to be very has to be there. So whenever in your agreement, if you have to describe the property, you always have a schedule which says the entire description of the property, all the adjoining areas, so that in case a property has to be identified from the schedule, it is very clear that this is the property has to be. Normally I have come across that in a schedule there are 4 areas of the properties, boundaries are not defined, right? So you have to be very, otherwise identification of the property is again a very important dispute or come arise when they, as far as the sale is concerned. Some sale deed are such lethargically drafted that the property which has to be conveyed or transferred is not located from the description of the property, because actual property description and the actual property which has to be conveyed, sometimes it is very difficult. So this is a parcel which is a very common feature. Another common feature would be the operative part. In the background of the recital, usually the operative part comes in consideration of. So now once the nature of document transaction is defined in the recital part, then comes the operative part where the rights and liabilities are defined. So liabilities would depend on the nature of transaction. For example, if I am a lender, then I'll my part would that I'll lend this amount. If I am a borrower, then I have to promise to repay the amount. Similarly, if case of a sale transaction, there would be a buyer, right, and there would be a seller. So if it is an agreement to sell, then the rights and liability of the buyer and the seller would be defined, right? So for example, in case of a property transaction, right, there has to be some set of conditions on the part of a buyer, right, that the properties have no encumbrance, right, or it is free from any defect. Similarly, if a seller, then I have to give a consideration of this much amount after the sale. So these are the in development agreement between a builder and the title owner. There are the different right and liabilities. So in the operative part, the parties which are under the contractual obligation will define the right and liabilities, right? That which part will be X person will oblige and which part will be the Y person will oblige. It has to be very clear. Another feature would be arrangement. It narrates and elaborate parawise how the recital and the operative part have been given effect. So once the rights and liabilities will define, right, then the another feature would be of arrangement. For example, if I'm making an investment as an investor, then I will invest or I will lend the amount in this much phases, right? Or suppose in a civil construction agreement, right, we have an arrangement that stage wise, if you start constructing the and stage wise I will release the fund. So arrangement depends on the nature of transaction. So once the operative part is conveyed, right and liabilities are defined, then the arrangement part will come, that how my nature of duty under the agreement will be enforced and what part I will perform. So that comes in under this feature. Then we have a testimonial. it is the conclusive part and the usual phrases it witness whereof. So once the arrangement part is done, then we have to testify that yes, I undertake that whatever the obligations are there, which I have to convey, I'll oblige by both the parties. Though this is the testimonial part which comes at the last stage, where we sign the document that we testified, right? We put our stamp and seal also at the last part of the document, which shows that yes, we agree to whatever things is written, and we testify that we will perform the part of agreement. Last is the attestation. Now, as I said, that certain documents require attestation, right? So, which means person other than party will witness the fact of the document being signed in her person. Such document are will shielded least. So, attestation is very important. So, attestation will have some witnesses. For example, if X and Y person are coming into a contract, right? So, A and B will be the witness, right? So, witness, why witness is very important in a contractual part, so that if any enforcement or a dispute will arises, that witness will in a court of law at the time of a dispute will testify, yes, that in my presence this transaction has taken place and I have witnessed to this transaction, right? So normally in a for example, in a sale deed, we have a witnesses, right, who attested the document, right? In case of a will also, because in will we have an executor once the person expires, and once the will has to be there is a executor is appointed in a lease. So witness is very important. Witness will have a evidentiary value to a document. So in later part of my slide, why attestation is very important, because when dispute arises, how the court interprets, right, is very important. Therefore, attestation part, even normally we notarize the document, right? Why we do the notary part? Because we do affirmation in front of a third party who is a notary, who has power under the Notary Act to do the affirmation part, right? He will identify the person and he will put his stamp and signature, right? So once the notary is done, you have evidentiary, your documentary evidentiary value is so high that the interpretation when the dispute arises is you have an upper hand. But if a document is not notarized or it does not have any witnesses, for example, two parties have come into a contract, right? They have a written agreement which is neither notary or they don't bear any witnesses, for example. Then what will happen when the document is enforced, or what would be the legal implications when the dispute arises within two parties, right? So such thing, to avoid that such dispute, always have witnesses to your agreement and always have affirmation before a notary. So this was the some very common features whenever you draft any document is required. Then we have a technical and specialized vocabulary clauses to be used in drafting of agreement and deed. So now first we have seen how the document has to be prepared. Second, we have seen the basic common feature which a document should have. Now we will see that what are the very important specialized clause, right, which has to be there in your document or in your agreement, so that there cannot be any legal implications, right? So first is ADR, which I say alternative dispute resolution, right? To resolve disputes outside the courtroom. The term typically encompasses negotiation, mediation, and arbitration. So nowadays, ADR is a very fast, very cost-effective mechanism for dispute resolution. And for professional also, we have as a professional also we can be arbitrator, we can act as a mediator, right? So that is another arena which has been opened up. So any document you create, and if you feel that you don't want to go to a court of law and have a very long civil trial for the purpose of your adjudication, then you can have a ADR clause, and there you can have even a 3 stage of negotiation. Normally we have a negotiation clause. So negotiation clause is like, for example, any dispute arises, then within a 1 week both the parties will try to negotiate internally at their own level. Then we can have a mediation clause which says that if a negotiation fails between the two parties, then a mediator could be appointed, which will have no legal binding, but he will try to mediate between the two parties to resolve the dispute within another 1 week. And after this 2 week period is expired, then we have a arbitration clause. So after these two stages of negotiation, adjudication fails, then at the third stage, a person can go to invoke the arbitration clause by giving a notice to the other party by invoking arbitration, and then arbitration to be appointed. Because normally we have seen that we have a common arbitration clause, but if you invoke the arbitration clause, as we know, it is a very cost effective, but again it is a matter of adjudication. So if you can have a negotiation and mediation clause, so that you can avoid that cost of litigation, and maybe what happens at the negotiation level also, sometimes the dispute have to be resolved. Now second important clause is assignment. The transfer of rights or duties by the assigner to the assignee. This may occur only by agreement or by operational law. For example, when someone dies or when a company is bankrupt. So we have very common that assignment of agreement is always there, right? So where normally in a loan transaction, we have assignment of dues, we have assignment of title, right? So assignment is like whenever you assign your right or property or maybe any duties to a second party, then that such assignment has to be enforced in accordance with law. Because for example, we have a securitization arrangement also, right? So that is also one kind of assignment. So assignment agreement is very important, and this clause defines that whether your right, title or property is properly assigned to the second party or not. Third is consideration, a common law concept which requires that a promise to be part of an exchange to be enforceable as a contract. So as I said, if you don't have a consideration part, right, that means that agreement is not a contract. That is a mere understanding between two parties. So if you see many MOU, which is nothing but a memorandum of understanding, will not have any consideration clause, right? Because that would be a simple arrangement. For example, if you see in Gujarat, we have a vibrant Gujarat concept, right? Where many investors comes and they execute MOU with the government, where their intention is that yes, they make some investment, but that MOU is not actually legally enforceable because there is no consideration clause is attached to that agreement. Yes, if you attach a consideration clause, then it becomes a contract, and once it is a contract, then it is enforceable, right? So that is the reason you have to be very careful whether your agreement is having a consideration clause or not, right? Third is default. The circumstances where an obligor under a contract is considered to be in a breach of a contract. In formal written contracts, defaults often include failure of representation or warranty to be true when made failure to. So generally, perform any affirmative or negative comment, insolvency or bankruptcy. So in an agreement, you should always have a default clause, right? So normally, if you see the civil construction contracts, right, there normally where the time is the essence of the entire agreement, right? So there the default is defined, right? That what nature of thing would be considered as a default, because in a contractual document, even the default has to be very clearly spelled out, so that in the event of default, right, we can say that whether there is a breach of contract, right, or that default has to be cured or not, right? So default is a very important aspect, that what would be the nature of default under any specific transaction. For example, in case of a loan transaction, repayment is not timely, that would be one of the nature of default. In civil construction, timeline is one of the default, right? So these are the some instances which I have narrated, that what would be the nature of default under your transaction, which we have to clearly define it. So that if such default is arise, right, you can clearly invoke the dispute resolution clause, so that your dispute can be resolved. Now, what would be the event of default? When a default remains uncured under any applicable notice or cure period, contracts typically provide that an event of default has occurred. Once an event of default has occurred, the obligee may generally pursue remedies. So these are the normally a cure period is one of the very important clause in case of a civil construction contracts, right, where the timeline is the essence of a contract. So in a turnkey project, for example, is something has to be constructed within a specific timeline, and the contractor has not done it, then for every delay, right, there will be a clause which has to be compensated. So events of default has to be defined. So for example, if something has to be done within some period, and if it's not done and he's delaying the entire project, then you can invoke the default clause and you can give a notice to the concerned person, and you can say that this is the nature of default, and within a period of 7 days or whatever the time period which you have narrated, you have to cure that defect. And if that defect is cured, then the agreement is not breached, and that agreement will again proceed to the next level. And if that default is not cured, right, then they would be liable for the liquidated damages. Right. Now, what is liquidated damages? Again, in my next slide, I will cover it. So events of default is very important, and the cure period. So you have to define a cure period, that within what time the nature of default has to be cured. If it is not cured, then you have a right to terminate the contract also, right? So this is a very important events of default. Now, estoppel, an equitable concept that prevents a party from raising an argument when the party has acted unfairly, fraudulently, or otherwise inappropriately. So the doctrine of estoppel normally we invoke in case of a fraudulent transaction, right? So in case of a fraudulent transaction or unfair transaction, normally the agreement or the contract is deemed to be terminated, right? So estoppel is again a very important clause, has to be incorporated, so that in case of any fraud, you can directly terminate your contract, right? And there is no requirement of enforcement thereafter. Now, execution, signing, the parties executing the contract by signing it. Second, performance, the parties may execute a contract by carrying out their obligation duty. So as I said, execution is very important. So execution is the person who affirms or signs the contract must have a valid authority by way of a proper document, so that that execution is complete, so that in future there may not be any dispute with regard to the execution part. As I earlier said, that in many contractual dispute, the first dispute and the defense which is taken, that the person who executed the contract was not properly authorized. This is the very common thing which we take. Now, other is a force majeure. Now, this is a very common, very most important clause, an act of God which prevents one party from performing the obligation owing under a contract. Commonly, such things as war, riots, earthquakes, flood, like are included. The common law generally takes a stricter approach to force majeure. Now, why force majeure is important? As we know that right now we are under the pandemic, right? Now, why pandemic is for example, in case of a pandemic, if you are not able to perform your contractual dispute, you can take a shelter of the force majeure clause, right? Force majeure is some unprecedented event which happens, which is beyond your control, right? For example, war, flood. Now, why this COVID is pandemic? Can you can enforce the force majeure clause? Because nowadays we have seen, because of this pandemic, by taking a shelter of force majeure clause, many contractual dispute has arises, right? So one of the interpretation would be whether this pandemic is can have a shelter of force majeure. Then yes, because the WHO, right, has recognized this event of this COVID as a pandemic, and he has declared that this is a nature of pandemic which is beyond control of the human intervention, right? That is the reason, if you don't have any force majeure clause also, for example, in your agreement, then also because of this pandemic situation, we face up, because of lockdown, many states have a lockdown, right, where Disaster Management Act and the Epidemic Disease Act, these are the two acts which normally invoke in case of such pandemic situation, right? So section 2 of the Epidemic Disease Act, and second is the Disaster Management Act we have. So in this case, where the state has the right to enforce any restrictions upon the citizens, right? So because of this lockdown and this thing, we are not able to perform our part of the obligation. So force majeure clause can be, we can take a shelter. So nowadays in many contractual disputes, force majeure clause has been invoked. So if you define it in your agreement, it is very good. But if it is not there, then also, if any dispute arises, you can take a shelter of this force majeure clause. Now, impracticability, a legal doctrine closely related to force majeure, but it is not a force majeure. If some unanticipated event makes performance of the contract unusually burdensome, some legal system will allow a party to be excused from the contract under the doctrine of impracticability. Different legal systems have varied requirements for invoking. So impracticability is a different from force majeure, but it is similar to force majeure. For example, in any nature of transaction, for example, because of lockdown, if you're not able to sell your goods, right, or because of these government restrictions, you're not able to, for example, a policy decisions has been changed, right, and for that you cannot implement your part of obligation, then that would be covered under the doctrine of impracticability, where because of this unforced unanticipated events, right, for the because of change in policy or change in law, or for example any restrictions by the government, because of you want to perform it, but because of this unanticipated event, it is impracticable for you to perform the contract. Therefore, you should have this clause in your agreement, is very important. Now another is indemnity clause, an agreement in which one party agrees to reimburse another party if it is held liable. And indemnity is in the nature of a guarantee, but typically is used when the party offering indemnity has some interest in involvement, control over the events leading to liability. Indemnity clauses are often found in commercial contracts. In all the lending transactions and documents, indemnity clause is always there, where in case if it is proved that the loss is because of you, then you have to indemnify the other party to whom the loss has been occurred, right? So indemnity clause is very important in your agreement. Then we have intellectual property, right given by law to a person in connection with intellectual, industrial, or artistic work. So we know that patent, copyright, and trademark, right? So in all the if your transaction covers the IPR part, right, then this clause is very important, because in many events the IPR is the only assets which based on the, for example, for many startups, if you see, the only their asset is their IPR, right? So in many startups, IPR clause is very important in your agreement, because nowadays, if IPR is not protected, right, then it may have very legal complications in future. Now, license clause. Now, what is license clause is? License clause is like you have a permission to use, right? Like we have a license agreements also. For example, if I am a owner of any IPR or any process, right? So I will give license to a third party to use that arrangement for limited purpose, right? So licensing means you are not giving your ownership right, but you are giving a permission to some person to use your uh, uh, process which is of your ownership, right? So we have a license agreement with regard to IPR also. We have license agreement with regard to the property also, right? So licensing, we have leave and license agreement means that you can enjoy and use the property, but you don't have any right of holding over the property, right? So license clause is very important. Then we have a lien clause. Lien is a creditor has a lien on a property. In case of a default, right, then lien clause will be invoked. Now, why lien is important? For example, if you have any transaction with regard to sale and purchase, right? For example, if you are selling a machinery, right, or any industrial where which has to be big industrial equipment has to be installed at the client side, then you can have a lien clause. For example, if as the payment has to be made over some period of time, right? So if you have a lien on that property, for example, in case of a manufacturing unit, if you have a lien clause, then lien means that in case if he has not made the entire payment and if a default has been occurred, then you have a lien on that property. So even in future, no third party right would be created on the machinery or on the things which you have supplied. So lien clause is very important. So in all the sale purchase transaction, you can have this lien clause also over the property. Then we have a liquid damages clause. So as I earlier said that we have a clause of default, events of default, right? That what would be the nature of default, and then we have a cure period, that if the default, within what period that default, temporary default, can be cured. But if you don't have if that default is not cured, right? For example, in civil construction contract agreements, normally time is the essence. So for example, if you want to complete a project within a 6 months, but if he completes within 8 or 10 months, right? So he has crossed the timeline, right? So if you have a liquidated damages clause, that means that for whatever, it is kind of a penalty clause. That means if he's failed to perform the timeline, right? So for the more he has stretched beyond the agreed period, for example, for he has completed in 8 or 10 months, then you can have a liquid damages clause. Normally the 10% of the total project cost is normally have as a term as a liquidated damages. So you can impose a liquidated damages upon the person who has not performed within the specific timeline. So this clause is very important. Second is the risk of loss. Now this clause is normally who bears the risk of if the goods covered by a contract are damaged or destroyed. Risk of loss is particularly important when goods are being transported long distance between the seller or buyer. So this clause is why it is important, because if you have a nature of transaction perishable goods, right? And in case where in the perishable goods, if the transaction or the delivery is a very long distance, right? So if you have a risk of loss clause, right, then the seller or the buyer, right, may take such liability that if any loss is occurred in the case of a transaction, right, then he will bear the loss and he will not create any liability. So in this clause, a buyer or seller may take the risk, for any kind of loss, because of the maybe the goods may get damaged, right, or the goods may not be in a proper form. So in long distance transaction also, this clause is very helpful, so that you can protect, if you are a seller or buyer, right, you can shift the risk of loss on either of the parties, and this is how you can draft this clause. So now we have a termination clause process in case of a non-performance or breach of contract. So termination clause is very important. In many cases, you don't have a termination clause, that in case of any breach, right, what would be the notice period? So normally, generally in employment contracts or in the civil construction contracts, we have a termination clause where we have a notice period that within 30 days, right, your contract will be terminated. So termination clause is very important, which gives a clarity in case of a non-performance or breach of contract. Now, clause of severability. Now, doctrine of severability is very important. The characters of a contract that allows for removal of duties or portion that are incorrectly or illegally drawn up. Now, what is doctrine of severability? Now, in many transactions, what happens that sometimes because of the change of policy, or maybe something which you have entered into is not legal, right? For example, you have created a document, right, to nullify the effect of law, right? Then that document is basically a void document as per the contract act, right? And that document is not enforceable. For example, if I have to do something in accordance with law, and if I create a document that to nullify, so doctrine of severability, if is there in your contract, then your entire contract will not become void or not enforceable. So that portion which is illegal, right, that portion will be removed, and other clauses of the agreement will remain as it is. So that will not affect on the performance of contract. Therefore, doctrine of severability is very important, because sometimes if something illegal happens, right, you can cure it, and your entire document will not become void or not enforceable. Now, last is judgment, precedent decided by court of law. So we have to be very updated with new precedents also, because sometimes what happens that a change of policy or maybe a judgment of a court of law will have a bearing on your transaction. So normally, if you prepare any document, then you can also define your point of entire drafting of the clause, if you are relying on a precedent for the is enforceability. So this is how precedents are very important. So shall we take some break, or I continue with my presentation further?
Chairman, sir.
Yes, sir. We can take a 10 minutes break, sir.
We can take a 10 minutes break, and we have some question and answers also.
Yes, yes,
So
yes.
so we will be taking till 7:45, right?
Yeah,
Yes, sir.
7:45, sir. And Vishalji, small request. I request you to explain about share purchase agreement also.
Yes, Chairperson, I'll explain it.
Okay, okay, please.
So because after this I have evidence part also and question answer also. So in that we have deal with many question and answer also, because I want more interactive so that the concept will be more clear.
Great, sir. There are some questions in Q&A also.
Yeah, that I'll taken up.
Let us have a break for 10 minutes and then we rejoin.
Yeah.
Thank
Okay.
you. Thank you.
కొన్ని క్వశ్చన్స్ చాట్ లో కూడా ఉన్నాయి సార్.
చాట్ చూడలేదు, ఇక్కడ 13 క్వశ్చన్స్ ఉన్నాయి.
చాట్ లో కూడా కొన్ని ఉన్నాయి.
ఉన్నాయి అవును.
ఒకసారి అనౌన్స్ చేయండి సార్ మీరు ఒకసారి.
I request the participants to put up their questions only in the Q&A box. Some of you have sent your questions in the chat box, so kindly retype them in the question and answers box so that it will be easy for the speaker to answer at one go. If your question is in chat, I think it has a very high chance of not being answered. So kindly put all your questions in the Q&A box. Even if you have already put it up in the chat, kindly retype it in the Q&A box. It's a request to all the participants, please. Sanjay Gupta ji, no audio, no video because we are having a break. Very shortly, we'll be resuming. We had given a 10 minutes break, so 10 minutes is almost over. So any moment, the learned speaker will be back on the screen. Chairman sir, I think your request for a share purchase agreement is very much justified because we have seen share purchase agreements running into several hundred pages.
100 pages.
And some in a very crisp and short manner, but all depends on the facts and situations of the case. And
Yeah, Bhanu sir, recently because last 3 years, 2 years I'm attending for NCLT. And the traditional way of presentation little bit now is gone, sir. Even judges and members also looking at a CRIPSI presentations. Previous presenting petition 150, 200 pages. Now they are looking at 20, not more than 20 to 25 pages. And there
are your drafting skills
are more number of pages.
You remember in our younger days in school, we used to have a concept called Prezi writing. Not only school, up to the degree level also, we used to have Prezi writing. I don't know whether it is there now because it's really a very long time since I left school and college. And the Prezi writing will help you to develop these skills of reproducing a longer version into a crisp and short version without losing the main content. So I think you should also plan one small one day. We'll have a session of 3 hours. Maybe probably we'll split it into 2 or 3 speakers. Sentence formation, grammar, and concept of Prezi writing. Because some of the youngsters who are just into practice, they
yes,
may...
sir. Along with that, I'm one more thing we need to add, sir. Legal phrases and maxims. That's also very much important. Small, which are very much useful and which are useful for our regular practice and presentations or petitions.
Yeah. Because all these come into play when we are drafting, especially in caseless assessments, that legal phraseology, like the Latin phrases, basically they are
Latin phrases,
all those
legal maxims. So as you rightly said, we will plan 2 hours program.
Yeah. I think the learned speaker is back, so all ears to you, sir. So before you start, sir, unmute, sir.
Yeah. Yes.
Before you start, sir, see, we had made an announcement to the participants to put their queries only in the Q&A box, because some of them have already put some of their questions in the chat box. We requested them to retype in the Q&A box so that it will be very easy for you to answer all the questions in one go. And I also told them as a whatever legal word you can say, we told them that if it is in the chat box, we might not answer.
Yes, so, okay. Fine. So shall I take Q&A first, or I shall complete with my presentation first? What do we say?
Up to you. Maybe if you can clear the questions up to now also, they will be happy.
Yes. So I'll just read out the question and answers, right?
I think Chairman sir, we can, because you have only 16 questions, so I think we'll ask the speaker sir to finish them off.
Yeah, actually that is better. He's also asking for a interactive session so that.
Yeah. So I'll take the question and answer first, and then I'll begin with my presentation.
Yes, sir.
So
Please.
first question is a mediation conciliation agreement similar to an award under the arbitration agreement?
Yes.
Right. So see, mediation and conciliation is different, and arbitration is different. So mediation normally is not a legal binding effect, right? So normally, suppose if there is a mediation clause, if even in many contractual disputes, court also appoints mediator, right? So just to amicably resolve this, because if there is a mediation report, is not a binding effect. Once the arbitration is the adjudication process, so after the arbitration take place, the arbitrator will pass an award, right? And that award has to be implemented as a decree after 90 days, right? And you can challenge and avoid. So mediation and a negotiation is a non-binding process, more kind of a formal process. And arbitration process is a legal process wherein entire adjudication of take place between the parties, and arbitrator will pass an award, right? So this is a basic difference between the three aspects. Document executed with lesser stamp charges as that of required is curable one. Yes. So if your any document which is required to be sufficiently stamped as per the Stamp Act, right? And if you have not sufficiently stamped it, right? So that is a curable defect, right? And you can cure the defect by putting up extra whatever the deficit is there, and that is curable, right? So in many mortgage documents, sale deed transaction, it has comes that the authority will impound the document, because once they're scrutinized, there would be a deficit. So it is a curable defect and a temporary defect, right? Sir, any website is there where we can find stamp duty of all the states? Every relevant state has their own Stamp Act incorporated. So you have to refer specific state-wise where you execute your agreement. You know that what would be because in many states there would be a local amendment to that effect.
Yes.
Does the trust deed required to be witnessed? Yes. So as I said, any document, if have witnesses, right, will create a evidentiary value to a document, so that in case of a dispute arises, right, so whatever witness will be there, you in a court of law, they can come as a witness, they can depose before a court of law by way of an examination in chief and cross examination. And this is how the evidence recorded in a dispute. Witness is very important. Otherwise, if you don't have a witness, then any dispute between the two parties, right, to prove the facts of the case would be very difficult. That is the reason witnesses in any document are very important. So whether it is a deed or any contractual, at least two witnesses from each party is required to be there. How do we decide which document required witnesses? So that will depend on your nature of transaction. If you feel that the nature of transaction is very complex or very monetary wise, if any commercial transaction is there, witness is very important. Otherwise, if you don't have a witnesses, right, then to prove your facts before a court of law, because in my evidence part, I will take the entire adjudication that what are the witnesses, type of witnesses as per the Evidence Act, why it is important. So that depends on your nature of transaction. In normal, for example, MOU transactions where you don't have any consideration part, in that if there are no witnesses, if it is not enforceable as a contract, then witnesses would not require. But if you want to evidently impose that document, then witnesses are important. What is the extent of a validity of a notarized document vis-a-vis a registered document? Now, these two things are very different parts. Notarized document means a notary is a person who has a license given by a government under the Notary Act, right? So he is a person who has a power of affirmation. Affirmation means that in his presence, right? Like we have a oath act, right? Commissioner of oath is there. So, for example, if you see in a court, we have a registrar, right? Registrar have a power of oath. So there is an oath act. So similarly, notary is a person who has a power with in presence, whom presence you can have affirmation. So once an affirmation is done before a notary, you have to put your signature in the his notary register also, which is also a part of a record, right? So in case of a dispute arises, for example, there would be one dispute that this is not my signature or I have not signed this agreement, for example. But if it is a notarized document, right, then there would be a signature on the agreement, as well as there will be a corresponding signature in the notary register. So you can court can issue the summons to the notary can produce his record, and the signature could be compared. Even the notary can give as a witness also, he can depose before the court that this was so and so person who has affirmed in my presence, right? So this is how evidentiary value can be proved. Whereas with a registered document means that under the Registration Act, if any document is compulsory required to be registered, then only that document could be legally enforceable. But if it's not registered, then that document cannot be legally enforceable. So this is the basic difference. In general, parties will not sign before a notary and the document was notarized. In general, parties will not sign before notary and the document notarized. What is the value of notice of any dispute arises? Generally, parties will not sign.
Sir,
Normally,
what happens is, sir, at least in Hyderabad, you
Yes.
don't go to a notary to sign. What you do is you just send a document with a Xerox. He just notarizes and returns the original. The query is asking such a situation will happen.
see, normally, whenever affirmation is take place, right, you have to be physically present before a notary, and he will take your identification, right, and thereafter you have to put a corresponding signature in his register. This is a basic, and that person who is also has to be identified by an advocate or maybe a person who knows it. So affirmation is normally legally is done in his presence, but what practice we adopt, that is the reason nowadays whenever any document is there and despite it is notary, the signature doesn't match. So that is will create a professional negligence on the notaries also. That is the reason in Gujarat now it is compulsory for all the notaries to keep a record of a document, right? So that in case of a dispute in land grabbing cases, many things this entire practice happens where actually party is not the one who has affirmed the signature on the document. So, but this is not a correct practice. You have to affirm in his presence only. Otherwise, you can have a criminal case also against him, against the notary and the person who has maybe has put a false signature of the case of forgery. It can also be registered against that person. What is the difference between a contract, agreement, and MOU? Yes, this I will take in my next just after this session. That what is the basic difference between all the three things? Do partnership deed to be notarized? See, I said it is not compulsory that you should have a document notarized. But if you have a document properly notarized, then the evidentiary value of the document becomes very high. And it is very easy to prove before a court of law in case of a dispute. Because a notary is an independent person. So, for example, if you don't have any witnesses also in your agreement, and suppose if it is properly notarized, then if you have any specific performance, if you file a case of a specific performance on a contract, and if it is notarized, that notary is an independent witness, because there are other types of witnesses that I'll cover in my evidence act, that it is an independent person, right? So when he deposed before a court of law, his evidentiary value will be considered at a very high pedestal by a court. That is the reason notary is very important, and I suggest that all the documents is required to be properly notarized for the evidentiary value purpose. Clauses of the contract can be enforced in case of any violation of the agreement contract. Yes, if you have any violation of a contract, it can be. If you have a, I just didn't understand the question properly. Clauses of the contract can be enforced. So that depends on your clauses. Whether in case of for example, a fraud or something, then by virtue of fraud, the contract would be terminated. But if there is any violation, that depends that what are the clauses which you have incorporated. Because in a contractual dispute, as I said earlier, beyond the readings of the contract, we cannot travel. So we have to find a way between the clauses of the agreement. In case of a government contract, when we do not have a choice of clauses as they have standard clauses, and when no arbitration clause is there, then can we opt for arbitration? if there is delay and longer disposal timing before the civil court and the claim? This is a very good question, that in government contracts, we don't have any choice of any negotiation, because normally we accept all the works from the government as our payment are secure. That is our mindset. But yes, if you don't have an arbitration clause, there is a recent judgment of the Supreme Court that if you even don't have an arbitration clause, you can opt for arbitration, right? That judgment citation I will share with you. So in case of no arbitration clause also, now there is a recent judgment of the Supreme Court, which says that you can invoke the arbitration, and you can, but for that you have to, before going to the civil court, you have to be the first party who has to invoke the arbitration, right? By giving a proper notice under the Arbitration Act. In case of a dispute, and if both witnesses is deceased, then what is the implication? Yes, now in this case, that will depend upon that what are the nature of evidence you bring on record for the purpose of to prove your facts, right? So in my evidence section, I will cover that what would be the legal implication if there are no witnesses attached to a contract, or maybe if one witness dies, then how the evidence has to be brought on record and how the evidence to be recorded. That I will take in my next session. If the recipient signed a receipt by recipient for having cash check received without a revenue stamp, in such cases it is usual that affixed revenue stamp and cross the same. Is this practically legally tenable? Receipt, I see. I don't understood the question, that received without a.
What is asking is,
Yes.
sometimes we don't affix a revenue stamp at the time of signing, and we don't sign across the revenue stamps. Then later what we do is, after the signature is done, we affix the revenue stamp below and strike off the revenue stamp.
Yes.
Like we put 2 marks and cancel it. So he's saying, is it valid or not? He's asking whether it is valid or not.
See, in case of a cash transaction, if you have received a cash, if you are giving a receipt of acknowledgement, right? So that depends on depending upon the dispute, that is legally valid if your signature can be properly proved, and if you have received any cash transaction, if you're legally able to put your signature, and because sometimes what happens, even the receipts are to be forged, right? So that is depend upon the nature of dispute. So it is, yes, legally tenable unless the dispute arises and you are sufficiently enough to prove your signature on that document. Sir, is registration of share transfer form is mandatory or paid the stamp? Now, share transfer, yes, that will depend upon the stamp, nature of stamp act. So whatever nature of transaction will have to be sufficiently stamped or not. That will depend on the nature of transaction. When MOU can be enforceable since it is not an agreement, since constitution, how you can take pressure to bind the parties? See, I tell you that I'll take the next session, that MOU, agreement and contract, what is the basic difference, and how you can protect it, what is the consideration clause, that I'll take in my next session. In a partnership deed, there is a change in partner's salary, whether this amendment to the deed be made on green sheet and attached to the original partnership deed without stamping. So whenever there is an amendment to any deed or any contract, right? So that amendment has to be freshly incorporated, or you can have a supplementary agreement to that effect, and that you can have make up part of the original agreement. So normally whenever you prepare any document, so in future, if there would be any amendment to that original document or deed, so you can have a clause that in future, if any supplementary agreement or any amendment agreement will be incorporated, then that would be treated as a part and parcel of this original document. So such clause you can incorporate, right? And this is how you can have a further amendment to the agreement, and that could be a part of the original document. Since it is called arbitration. Yes, sir.
To interrupt here, the questions are increasing, so I would like you to take up a couple of questions more and then proceed with your presentation, and the balance will take later, because the as you are answering, the questions are increasing.
Yeah. So I'll do one thing. I'll continue with my yes, I'll continue my presentation, because I have to take that legal opinion also. That is also very important. Okay. Yes. Then I'll stop here for a moment and I'll continue with my presentation.
Done, sir.
Yes. So normally, am I audible now?
Yes, sir. Yes, sir.
Okay. So now this is a very common maybe confusion we say, or maybe a common myth, that what is the difference between an agreement, MOU, that is commonly we known as a memorandum of understanding, contract, and deed, right? So these are the main four common things we need to understand. So in generally, uh, all contracts are agreement, but all agreements cannot be a contract, right? So agreement is as per contract act. If you see, there are offer, acceptance, and consideration. So these are the three common facet of an agreement, where one party will make an offer, second party will accept acceptance, and third is for some consideration, right? So as I earlier explained, that if you have an offer and acceptance, right, but if you have no consideration party attached, then that agreement would not be a contract, because for enforceability of agreement to be a contract, consideration part is very important, that for what consideration you are entering upon the transaction. So this is the basic difference when you have to examine whether this any document, whether it is an agreement or it is a contract, and whether it is enforceable not, will depend upon the consideration clause, whether there is a consideration clause is attached or not. If there is no consideration part is attached to any document or any agreement, then that agreement is not a contract, right? So this is a main basic difference between the two documents, right? Now there is one another common understanding, that what is a memorandum of understanding. Memorandum of understanding is basically, there are two meeting of minds where two parties come into a basic understanding to start any venture, right? For example, tomorrow if I want to, as an investor, if I go to approach any government and say that I will invest this much amount, you give me this much facility, right? So this is for example, we have a vibrant Gujarat concept in all the state, where the state invites the investors and they execute MOU, right? So MOU is a basic meeting of mind and understanding where two parties agree that they want to intend to do it, right? But that intention is without any consideration. So if that intention is also not fulfilled by any of the parties, would create any legal implications, right? So therefore MOU is nothing but a basic drawing of a meeting of mind or arrangement between two parties who just intend to do it, right? So that is a MOU. So MOU is, that is the reason MOU is not legally enforceable, because that is just my intention to do it. But suppose if tomorrow I don't invest it, right, for example, then that doesn't mean that government will take any action for any breach of agreement. Yes. Now, but suppose if I enter into a contract with the government for specific arrangement, where I agree that within this period I will invest this much of land, and in that consideration, for example, if government has allotted me a land to set up some industries, right? So this is an arrangement with some consideration, where the government will give me some facility of land and other tax benefit, and based on that consideration I will invest or I will set up something, right? So that arrangement where parties obligation to perform is based on some consideration, and if that is not fulfilled, then would be termed as a breach, and that is a legal enforceable, and that is a contract. So this is how the basic difference between the three documents, right? So tomorrow, suppose you may say that the title of the document is not important. As I earlier said in my presentation, the content of the document has to be read in as a consonance to understand whether it is a contract, whether it is an MOU, or it is an agreement. Sometimes what happens, the title may be an MOU, but if you see the contents of the document, then would have been an entire obligation between the parties as a part of consideration. Then that MOU is also a contract. So the title of the document is not important. The nature of transaction, obligation between the parties for some consideration is very important when you vet a document, to understand whether it is a contract, MOU, or an agreement. So this is the basic important difference to identify any document. Now the fourth one is deed. Now what is deed? Deed is nothing where a transfer of any right, title is to be created by one party in favor of another, right? So for example, we have a very partnership deed, sale deed. What is deed? This is a kind of a document, conveyance document, where one party is intent to transfer his ownership, his right, or maybe a title, right, to the third person. That is a important. That deed is also is a one type of a contract where a consideration part is attached. So in normally there might be a one deed also where, for example, a gift deed, there is no consideration part is attached. But in other type of deed where the consideration, that is also one type of contract. That is an through nature of deed, we try to transfer any of our right or title or interest in any of the property. So these are the three some basic difference where you have to identify a document, whether it is a contract, whether it is MOU or it is agreement. Ultimately, that depends on the enforceability of an agreement is concerned, right? So that this is how you have to identify it. If any obligation part is attached with some consideration between the parties, then that is a contract and this is enforceable. In many cases of a specific performance contract disputes, right, where one party files a suit for specific performance before a civil court, or maybe before the arbitration clause, you have to establish from the clause of the agreement that this is the obligation and consideration attached between the parties, right? So this is how the dispute will arises, and this is how the things has to be interpreted. Now, this is a very important aspect between a document and the Evidence Act, right? So naturally, unless there is a dispute, all the documents are considered to be a valid in accordance with law, right? But when the dispute arises and it goes before a court of law for enforceability or for the performance of any contract, then in that case scenario, the interpretation of the document comes and the evidence part is very important. Now, that is the reason for all the professionals, some important aspect of Evidence Act which I have tried to be narrated here, so that whenever you prepare a document with proper evidentiary value, so that whenever there is dispute arises, you have a very good chances of adjudication and upper hand in case of a litigation arises, right? So Evidence Act applies to all judicial proceedings where the facts and relevant facts have to be ascertained, and on the basis of a conclusions have to be arrived in all the trial cases, both civil and criminal. So what is the evidence? Evidence means, suppose if there is a dispute between a parties and it goes before a court of law, right? Whether it is a civil, whether it is in the nature of criminal, right? Or whether it is an arbitration proceedings, evidence which will come on record will try to ascertain that in whose favor the court will decide the rights and liabilities, right? So that is will depend on the evidence which will come on record, and that has to be proved by the parties who goes before a court of law. Usually, all provision of Evidence Act do not apply to tribunals, and such sections are inserted in Constituting Act of a tribunal. So actually, entire Evidence Act, if you see the tribunals, which is our quasi-judicial tribunals, because tribunal has their own set of procedures. So they have full-fledged Evidence Act will not apply like in case of a civil and a criminal trial, right? But some part of evidence will definitely will apply in case of a dispute of any adjudication of any document is concerned. As stated in the initial part, a document in case of dispute requires to be tested on the touchstone of evidence through a court trial. So as I said, that once a dispute arises, whether you go through arbitration or you file a specific suit for performance in a civil court, or you file a criminal case in case of a forgery, right? In all the eventualities, you once the document is disputed, right, then the court will decide the evidentiary value of the document based on the evidence which will come on record. So based on the evidence produced by both the parties before a court of law, will decide that who in whose favor the court will ascertain the rights of the parties. Now, Chapter 5 of Evidence Act deals with documentary evidence, and it may be appropriate to look at some of the important provisions. Now, that is the reason Chapter 5 is very important whenever, because it is related to the documentary evidence. So whenever we prepare any document, any nature of agreement, right? So these provisions will definitely apply in case of a dispute arises, because once the dispute arises, then the real interpretation of the document and facts attached to the document comes into play before a court of law. Now, Section 61 says contents of documents may be proved either by primary evidence or second evidence. So for example, if you have any agreement or a contract, right? So if you have any dispute, if another party says that I don't abide to this agreement, right? Or he disputes some of the facts, or he dispute his signature or execution of the agreement, then other party has to prove his case based on a primary evidence and the secondary evidence, the contents of the document. So what is primary evidence? Primary evidence means the document itself produced in the court of law. For example, if I enter to any agreement with one party and there is a dispute of any transaction, or for example, sale purchase transaction, then I'll go before a court of law for the uh, enforcement of that agreement. Then my dispute is a contractual dispute. Therefore, first basic requirement would be that I will produce the original document which is executed between the parties, right, before a court of law as evidence. Because unless that original document doesn't come in front of the court, court will not ascertain it as an evidence, and court will unless that original document doesn't come on record of the court, it is not possible for you to prove that your case, that this is the original document based on which our rights and obligations are created. That is the reason whenever you create any document, right, between, or you any executive document, always prepare two original documents. One set of original document you give with keep with the either of parties, because normally what happens, there is one original document is there in possession of one party, other party may have any photocopy of that document, right? So that is the reason whenever you prepare original document for execution, prepare two documents and you keep original document with each of the parties, so that in tomorrow if he has to file a case, so he can produce the original document. Otherwise, what would be the remedy? Suppose if I don't have an original document in my custody, then a court, I have to file an application for the production of documents, and I have to say that this document is not in my possession and it is in possession of the other party. Then court can also summons the other party to produce the original document. But if you file a case, it is your obligation and duty to produce a primary evidence. That is the reason possession of the original document is very important. But suppose I don't have a original document with me, I have a photocopy, for example. So then what will happen? Whether based on a photocopy, can I file a case, or for enforcement of a contract? Yes, photocopy is generally known as the secondary evidence. So the appreciation of evidence will differ between the primary evidence and the secondary evidence, right? For example, if you have an original document, then the court will have a high regard to admissible of that evidence, because it is a primary evidence. For example, because of original document is produced in a court of law, to verify the content as well as the signature, right, on the original document is very easy, because it is an originally primary evidence produced in the court of law. But if you produce a secondary evidence, for example, if you file a case based on a photocopy, then the factual legal what I say, the veracity of that agreement considering the court will be difficult, right? So for example, if there is a dispute with regard to signature, then based on the secondary evidence on the photocopy, it's difficult to prove the content of the document. That is the reason, yes, you can file a case based on second evidence, but it is very difficult to prove it. So now in that, eventually what happens, suppose if I have a Xerox copy or photocopy, and based on a photocopy I filed a case against one person, and other party says that the signature on my document, right, is not correct, this is not my signature, right? And more complex to that thing is that there are no witnesses also, right? And that document is also not notarized, for example. So in that eventuality, what will happen, that how will you prove a case? Then in that case, you can file an application for the purpose of handwriting examination, right? And what is handwriting examination? That you have to file an application saying that the signature of the other party is correct, and that Xerox copy will be sent to the FSL. Or you can also take a opinion of a private handwriting expert opinion, and based on that you can put on record saying that his signature is correct based on this Xerox copy. But even for the FSL to examine it, you need to require the original document, because based on the Xerox copy you can establish a prima facie case. But if you want to prove your case without original document, signature also could not be verified by the forensic science laboratory, right? That is the reason importance of primary evidence is very important in case of a dispute. Now section 64, stipulate that document must be proved by primary evidence. So as I earlier said, that original document is very much important in case you have to prove your facts as well as evidence on record. When under section 65, the original is shown or appears to be in power or possession of a person against whom it is sought to be proved, or its existence, condition and contents have been admitted by such person, or when original is destroyed or lost, or it is a public document, etc. So as I said, section 64 said if you don't have a primary evidence, right, then section 65 empowers that if whatever document is in possession of other person against whom you have filed a case, or if that document is a public document, then even in that cases the court has power to call for the records from the public document to prove your case. For example, some of the document, like for example sealed deed, is a public document because it is a registered document, right? So any document which is a public document and it is properly registered, based on that document also you can file your case. That is the reason whenever you have an agreement to sell, for example, if it is properly registered, right, then that is a public document, because once you register it, it is a public document. So based on that agreement to sell, you can file a suit for specific performance, right, in case of any dispute, and the evidentiary value of that document will be very high, so that it is a primary evidence, so that you have a very good chances in winning the case in your favor. Now, contents of electronic record may be proved by producing the computer output containing that the information with all its material part and requirement under section 65B are satisfied. So earlier I said all the electronic record is regarded as a document under the IT Act. So nowadays we exchange a lot of emails. Even the contracts are exchanged through email, right? Transactions are carried out through email, right? For example. So suppose now if you have any dispute between the parties and you have a electronic record of your transaction, sometimes what happens, even the WhatsApp, right? Now normally in many transactions we use the conversation of WhatsApp as an, so there are many things, whether the WhatsApp or the email is there, whether that is a document or whether that can be regarded as an evidence in a court of law, then the answer is yes. Any electronic record can be is a document, and any electronic record you can rely upon as an evidence before a court of law to prove your case. That is the reason there is an amendment to Evidence Act. Section 65B says that any electronic record, whatever you produce before a court of law, has to be without any tampered, right? So suppose if I am taking any email or any WhatsApp printout from my suppose computer, which is an electronic thing, then whatever I print, I take out, and whatever thing I produce as a record, that has to be untampered, right? It may not be that whatever email I may, cropped it or edited, right, and then I produce before a court of law as an evidence, right? If whatever thing which I produce, which is tampered, then there would be a contempt proceedings against me, because I have produced a false evidence, and there can be a criminal prosecution against me. That is the reason nowadays, what if you want to produce an electronic record, you have to give certificate under section 65B, right? That saying that whatever electronic record we have produced, you have taken from the original output from your computer and it is not tampered. So unless you give that certificate along with the your document, then the court will not take any cognizance. If you produce that certificate, then court will take cognizance of that record as an evidence, because in that certificate, if anything is found tampered with, for example, if it is proved, then you will be liable for criminal prosecution. So, but if any case, suppose in a dispute, if any party has produced electronic record, for example, any email conversation and any WhatsApp chat, but he has not produced any certificate under section 65B in the support of that electronic record, then definitely you can take a defense, or you can take an objection that, sir, he has not verified or testified the contents of the electronic record by way of a certificate duly signed by him under the requirement of section 65B of the Evidence Act, right? So you can take such objection. Unless that certificate is not provided in his support, the court cannot take the cognizance of that document which any party produce. Therefore, you have to make sure, if you are producing it, you have to give that certificate, and if other party is producing it, you can demand that certificate, so that In case if you are able to prove that it is a tampered document, then you can lodge a criminal prosecution against that person. Okay, so that is the reason section 65B is very important. Now, in the quasi judicial proceedings, like in tribunals, we have summary nature proceedings, right? Because we have no stage of evidence like in a civil or criminal trial. That is the reason why this section is very important, because whatever documents normally we produce before a tribunal, right? Normally we just take a printout, we true copy it, and then we produce it in support of our petition as an annex or as an evidence. So if in such quasi judicial proceedings also, if any person has not certified as per section 65B, then you can take a plea in your defense that this document is not certified. That is the reason, if you see that in case of a banking transaction, electronic ledger which is produced by the financial institution in support of their case is always supported by Bankers Evidence Act, right? So they provide a certificate under the Bankers Evidence Act that what, because their ledger would be in electronic medium. So whenever they take a printout from as an electronic ledger, they have to give a certificate that whatever ledger they are producing as a document is not tampered. That is, if that evidence certificate is not there, then you can take a plea that this ledger which they have produced from electronic medium cannot be taken as an evidence or consideration by the court. That is in many DRT proceedings and in NCLT proceedings, when financial institute produce their electronic ledger, they forget to produce the Bankers Evidence Certificate in accordance with the Bankers Evidence Act. Now, section 67 requires that a document is alleged to be signed or written by any person's signature on writing must be proved and owner lies on the party who asset is. So now this section is very important. So normally we have a question that why the witnesses are important, why the signature is important. Because suppose if a person have signed the signature, right? That is the reason I would advise you that along with the signature, if it is possible, you always put a thumb impression in a document to testify. Why I'm saying this? Because signature may be disputed, but a thumb impression can never be disputed by any party. So this is a very good way to bind the document in the most legally confirmation way. So that is the reason. So whenever you allege that this is not my signature, right? Suppose in case of any constitutional dispute, then onus lies on you to prove that this is not your signature. For that, you may have a opinion of a handwriting expert in your support, or you can make an application to the court of law to send this document to the handwriting expert or to a government laboratory FSL in case you dispute the signature. A document required by law to be attested cannot be used as evidence unless at least one attesting witness has been examined. So that is the reason why I say that witnesses are very important. Suppose if in case there is a dispute between the parties and there are two witnesses, right? So suppose once there will be a dispute, I will call a witness who has signed as a document on witness as in my support before a court of law. That witness will depose in my favor before a court in by way of an examination in chief, and that witness will say, yes, this document has been executed in my presence and I know the content and it is correct, right? So this is how evidence will be brought on record. So the person who will come as a witness and will depose before a court of law in your favor, where he will testify the contents of that agreement. Similarly, other side will also get an opportunity to cross and cross-examination chief. A witness will be examined, one witness will depose and other defense will be cross-examined. This is how evidence will come on record, and this is how once the witness is examined and evidence is brought on record, this is how the after having that evidence on record, court will give his application of mind, and this is how the appreciation of witnesses also. There is a independent witness, there is interested witness, there is an expert witness, right? So there are different type of witnesses. So different type of witnesses will have different credibility for their evidence. For example, if I am your friend then I am your, or maybe if I am your, for example, a family relative, then I am an interested witness. So if I give evidence in your favor, the oppression of that evidence will be not high, because obviously other side will allege that I am an interested witness. But suppose if I am a notary and affirmation is done in my presence, then if a notary will come to depose before a court of law, he is an independent witness. Why? Because he is a person who is authorized by under the law to affirm the court. Therefore, he will say, yes, this agreement will execute it in my favor, and these are the two persons who have signed my register also. So that register will also be produced as a document, as an evidence before a court of law to prove the contents of the agreement. That is the reason witnesses are very important, and this is how witnesses are examined and evidence are come on record. So it is important to have an independent witness when you execute an agreement. Section 71 says that if attesting witness denies or does not recollect execution document, it may be proved by other evidence, the document forming the act, record of official bodies. So sometimes what happens, that a witness may come after a long time. He may not remember anything, right? So he denies, or maybe he said that I cannot recollect the execution of document, right? But suppose his signature is there, then you can show that document to him and you can say that, see, this is your signature, whether you can identify it. Right? Such questions are to be asked in the witness. He says, yes, this is my signature. Then you don't have to prove. That means the execution of document has been done in his favor and he has signed the document. But he says, no, I cannot recollect anything, for example. Then in that case, what will happen? You have to prove by some other evidence in your support, by getting some proof from the public documents, as I said, who can be a part of record, and based on that thing also you can. For example, in case of a signature dispute, what will happen? Suppose if I sign it, right? And if you want to match my signature, then what you can do, you can take out my signature from a public record. For example, I must have executed my signature from public, like from my Aadhaar card, or maybe some any other public document, which you can produce before a court of law as an evidence. Say that, sir, see, this is a public document, and his signature on a public document is similar to what signature he has executed in my agreement, right? So this is how you have to prove your case, and this is how you have to bring your evidence on record in support of your case. Chapter 6 of evidence deals with the exclusion of oral by documentary evidence. Under section, if terms of contract have been reduced to form of a document or required under law to be reduced, oral evidence is not admissible. However, any fact which may invalidate the document, such as fraud, can be proved. So normally that is the reason any agreement is required to be done in writing, because therefore if oral evidence is not admissible. But in case of a fraud, for example, a fraud has taken place with me and document has been created behind my back, or without my consent, or maybe without my signature, in that case, in a criminal trial, even without any documentary evidence, you can prove your case by examining the witnesses, or by sending that document to any expert opinion, FSL. Because if once the document is examined in FSL also, that is known as an expert evidence, and he will also come before a court of law. But whatever report he has submitted, he will also affirm it. Under section 99, persons who are not parties to a document or their representatives may give evidence on any facts tending to show contempt agreement wearing the term. For example, suppose if there are no witnesses, right? But then also if there are no witnesses, but if some person was present when the document was executed, then you can also bring that person as a witness in your favor, and you can examine him as a witness, and he can depose, right? But that will depend on the court, that to what extent that deposition is considered. If it is an independent witness, then his evidentiary value will be very high. But if he is an interested witness, then again the evidentiary will depend. So the responsibility of proving a document is called burden of proof, and it lies on the person who asserts or who case will fail. If it is so, the burden of proof is on a person who asserts it. Therefore, if I have a dispute, then it is a burden of proof is on me to prove my case. And if other person is objecting to some defense, then burden of proof lies on him, right, to prove case. So burden of proof in case of a criminal and in case of a civil trial is very different, because in criminal cases you have to just prove a probability, right, and you have to create a doubt. But in case of a civil trial, you have to prove beyond reasonable doubt. This is the basic difference. Now, many queries are regarding the Stamp Act. Now, why so important? Because even if the document is very accurate, if it is not stamped, that it is not admissible in evidence. Therefore, if you have any document, if it is not sufficiently stamped, you cannot enforce that document as a matter of right in and it is not considered as evidence also, right? So you have to cure it. Why central and state operate together? It is a concurrent subject. Indian stamp lays down the stamp, right? So both the stamp act concurrently. So depend upon the types of transaction within the state, stamp act will be applicable. So there are various methods of stamping. We know on e-stamping is there, franking is there. So that you can use as a manner of conveyance. Now, what is adjudication? Power is vested with the stamp authorities. Like, so we have a inspector general of stamp, like in many states, which is an authority which take care of the stamp duty, right? So whenever a document is registered and whether it is not sufficiently stamped, this authority adjudicates it. Now, what is impounding? If any public officer is discharged of duties who has authority to receive evidence, forms, and opinion that document is not duly stamped, he can impound it and send it. So impounding means, suppose if I have produced a document before a court of law, right, or maybe before any officer, and if he feels that this is not a duly stamped, then my document will be impounded. For example, court can also impound a document, and court will send that document to the stamp authority for the purpose of adjudication. So in many cases, any authority has a right to impound the document and will send to the concerned authority for the purpose of adjudication. Then you have to approach the stamp duty for his rectification, or you can pay the stamp duty. Can an understamped document still be valid? By paying a yes, it is, as I said, it is a temporary defect. You can cure it by paying whatever the penalty and other things. So these are the some of the stamp which is required on the nature of document which I have listed. So so these are the things which I why the evidence is very important and affirmation is very important. Now,
Yes.
shall I take my
You
legal
can take
opinion or Q&A?
Yes, sir. You can, sir. You can, sir.
So I quickly want to take a legal opinion, that how the legal opinions will be drafted, and I will share a specimen wherein how you can draft a very conclusive legal opinion, so that in case your legal opinion is acted upon or a transaction taken place, you can have a 360-degree approach to it. So I will quickly take up one legal opinion. One second. Whether it is not. Can you see it, sir? Is visible?
No, sir.
It is not visible.
Not visible.
You give me 5 minutes. 1 second. I'll just load it once again.
Members, please post questions in Q&A only. Please don't post in chat. We'll share the presentation. We'll upload in Hyderabad website, and you can download from there.
Just 1 minute. I'll just upload it. Just 1 minute.
Vishalji, I'm having that document. Can I share? Is it? Can you check?
Yeah, if you have, then you can share it. That would be easy.
Yeah, I was having your legal opinion documentation. Just a minute. I'm also trying it.
Shall I email you then?
Yes, sir. Please mail me, sir.
Yeah.
Actually, I'm having the copy. It's to download.
1 second. I'll just email you because that is very important actually. What will be your email ID?
Yeah, Hyderabad at ICA.org, sir. We send a mail to you. You just reply to that.
1 second. I'll just.
Chairman, I think some of the participants have raised hands. We request them to put their queries in the Q&A box only instead of raising hands.
Yes, sir. Yes, sir. Vishal, I got it actually. Yeah, just I'm sharing it, please.
Yeah.
I'm having with you that. I think is this one you're talking about?
Yeah. Yes. So I'll edit and send you. Okay. So this is one legal opinion.
Sure.
So this is what. Am I audible now?
Yes, Vishal.
Yeah. So here, what was the issue in consideration, which I'll just brief the participants, that JPL was under insolvency, right? So what has done that JPL is a company who has assigned his receivable to SREI Shri. So that so during the process of insolvency, there was a legal issue whether the assignment given by JPL to Shri was in accordance with law or not, because the receivable which was given by JPL was subsequent to earlier, because there were earlier loan transaction also. There were other lenders also who already executed their legal documentation of their lending transaction prior to this transaction, right? So we had to give an opinion that whatever the agreement which this JPL and Shri has undertaken with regard to receivables, whether what would be the fate of this transaction. So now can you give me the host so that I can, or
And I think
yeah. Okay. So in arriving at the opinion, explore following. So first, whenever there is a legal issue, right? So you have to narrate that what are the documents which you are taking from a client to form an opinion. Okay. So for example, you can see the first documentation which was executed in 2010 by JPL with IDBI, Bank of Baroda, Canara, and Indian Bank. So these were the 4 banks, which was a consortium. So prior to this, consortium was already there who has lended this transaction to JPL. So this was the first hypothecation document. Now, second document which we studied for the purpose of opinion was hypothecation, which was executed by JPL with the Axis Bank, right? Third was master restructuring agreement of 2013. So first was 10, 11, and 13. And fourth document was deed of hypothecation executed with JPL between the PNB, who was a security trustee by the consortium agreement, right? Now, and the last document, E. This was the document which was in dispute, for which we have to give an opinion, because this document which was executed in 2016 by JPL, where all the receivables was assigned to this lender S Shri, which is SREI, right, in 2016. So now we have to compare this document E with the earlier 4 document which was executed prior to that, that what would be the effect of this document E, right? So this was, we have to give an opinion. So these are the 5 documents which we have examined. So therefore, whenever you give a legal opinion, you have to narrate the sequence of document which will undertake for the purpose of scrutiny. Now, as I said, that the transaction was with regard to receivables. So now we have to jot down that what are the laws which would be applicable for the purpose of this transaction of taking receivables of a company, right? So now first is a factoring agreement, right? Now we have a factoring regulation act. So we have to examine this document E, which is a disputed document, in terms of factoring agreement, whether the arrangement of receivables by JPL and Shri, whether it is comes under the purview of factoring agreement or not, right? So now we have stated that this agreement was executed in 2016. So now before examining this aspect of factoring, we have narrated that what is a factoring regulation act. So now section 2 define the factoring business. So any company or institution which has a factoring license can only be entitled to enter into this business of factoring, right? So section 2 says factoring business means acquisition of receivable of assigner by accepting assignment of receivables, right? So this is a factoring arrangement. So this is a section 2, we have defined it. So this is a factoring business. Now second point, you see, to identify this agreement as factoring agreement as per the factoring regulation act or not, what are the requirements? So first we define that what is a factoring agreement, section definition we have stated. Now we'll define this agreement, whether this agreement is fulfilling the requirement of FRA or not. So first we have to see that, one second, what is a factor? Means a non-banking financial company which has been granted a certificate of registration. So you have to take a license, right? So first requirement is that who company, suppose Sri is a factoring company, then it must have a license as per FRA, right? Second, you can just move. So therefore, as per every factor requires registration as per section 3 of the act, right? So it requires an RBI license. Now here you can see this is a link where all the factoring agreement company who is into this business and who has been granted license will be published by the RBI. So you have to check from this list. Suppose if Shri is a factoring company and he is entitled to do this business, he will be there as per under this FRA agreement, right? So you have to check it. So when we check, we came to know that C has no factoring license, right? Now further section 7 says that assignment will be effected by an agreement in writing. So any factoring arrangement has to be in form of writing, right? So there has to be a written agreement to that effect. You can move.
Yes.
Yes. Now you see section 19. So if there is any factoring agreement is there, then it has to be compulsory registered with the central registry in requirement of section 20 of the SARFAESI Act. Now we have a central registry is to be there, so that why it has been created, that every factoring or lending agreement has to be registered, so that you can take a search of it and you can see that this agreement has been executed. Now let us yes, so just about that. Yeah. Therefore, considering the above legal requirement, though agreement E creates an assignment of receivable, but the agreement does not appear to meet the legal requirements of FRA. Hence, sanctity and enforceability of the present agreement under FRA is doubtful. So now this is we have concluded. We have examined that they have no license, right? Though there is an agreement in writing, there is no license. That agreement is also not registered as per the Central Registry Act, right? So this agreement does not meet the requirement. Therefore, there is a doubtful that this cannot be regarded as a factoring agreement. So the one thing we have examined. Now, other agreement executed prior to Shri. Now let us examine document A, B, C, and D. So as I earlier stated that document E executed in 2016, whereas earlier document has been executed prior to 2016. So we have to examine that whether earlier document is legally valid or not. So first is the hypothecation asset includes receivable, right? So there has been a charge created in document A. So that is also very prior in 2010. So that is a proper document. So there is no legal complication attached to that document. Similarly, we have examined document B also. If you can just move. So you see clause 3. Yes. So we have said that clause. Just if you can move a little bit upwards.
Upwards. Yeah.
Yes.
Here, okay, sir.
Yes. Yes. So document A is the hypothecation document, and that document is clearly says at clause number 2 and page number 4. See, you have to also mention that you are relying on which clause and which page number of the agreement, right? So we have clearly mentioned that this hypothecation asset has been is a proper document in favor of the consortium, and it has created first pari passu charge. So what type of charge is also there, that also we have defined it in our opinion. Now similarly, we will examine a document B, which is subsequent in 2012, right? So this is also a proper document at clause at page number 6, clearly defined. Hypothetical asset will be free from any kind of encumbrance, and without concern of question, the borrower shall not create any charge on encumbrance. Now see, this clause is very important. This says that the borrower will not create any further charge on encumbrance on the hypothetical asset without the consent of the consortium, right? So if you see the document E, which is created subsequently, is without the consent of the consortium, right? Therefore, the legal sanctity of that document is again a doubtful. So that this will have a first pari passu charge. Similarly, document B also we have examined, which is with the Axis Bank. As per clause 2 and page 3, the receivable hypothecated, including all current assets by way of second charge, including second charge. So as per this document, Axis Bank is having a second charge over the book debt. So first is having a first pari passu charge. Document B is creating a second charge, right? So this is again the clear document. Now document C, if you can move above. So now document was a document which was created by a security agreement, which defines the rank of charges. So considering this document, the book debts of the company now will have pari passu charge among lenders. So now here again there is a modification of charge among the lenders. And now there is a last document, document D, which says that the third schedule assets are receivable will have a pari passu charge to the working facilities. Now, considering this document, the book debts of the company will have pari passu charge among lenders to secure working. So this is how all the 4 documents which I have examined will have the different charges among all the lenders, right? And these 4 documents is executed prior to the document which is document E. Now let us examine the legal position. Now see, once you clearly examine the documents, right, and you narrate the whether that the document is legally valid or not, you have to explain the legal position, that what is the charge, because here the dispute is regard to the charge only, whether prior charge is correct or subsequent receivable charge is correct of JPL to the Sri, right? So earlier the legal opinion is based on the position of the charge, that who is having a valid charge and who is having not a valid charge. So first we have to say what is charge. A charge is basically a right which is created by a person, that is a borrower, on its assets and properties, whether present or future, in favor of a bank or a financial institution, that is lender. So as we see, charge is what that a borrower will create in favor of his lender, right? So here see, since it is a company, we have picked up the definition of a charge from the Companies Act. See, section 216 is the companies define the charge, right? Which is nothing but an interest or lien created on property assets of a company. So here we have to see, if it is a company, we have taken a definition from the Companies Act. If it would have been a firm, then we have taken would have taken a definition from the Firm Act, right? So this is how we have to define a charge. Now, what is the characteristic of a charge? So in the charge, there would be a borrower and a lender, and the subject matter of a charge, current or future asset. The agreement of the charge, whether written or there may be borrowed in favor of a lender, which reflects his intention to offer one or more specific assets. Therefore, what is the characteristic of charge means that a borrower will offer to his lender all the specific rights created. Now, duty of charge under the Companies Act. So, because since it is a company, we have to see all the perspectives of a company. So, under the Companies Act, it is compulsory that a charge has to be registered with the ROC, right? Under Section 77 of the Companies Act. Therefore, as I said earlier, for a valid charge, you need to have a proper registration, right? So, since it is a company, you have to register your charge with the ROC as per Section 77. Now, registration of charge will with ROC is subject to at your end. Now, you see, suppose if I am having a valid charge, then obviously my charge will be registered with the ROC. Now, whether the charge is registered or not, in my legal opinion, I have shift the onus on the client to identify, right? That whether this document having a charge or not, you have to see whether it is properly registered or not, right? Now, presuming, now I have to give my finding. Presuming it is done, execution of agreement, deed of hypothecation in the year 2010, 11, 13, right, is having a valid charge because this document had the valid stamp duty, it had a valid charge registration, right, as per the Companies Act, and it was also there in the central registry as per the requirement of the SURFACE Act. So my finding is that earlier 4 document is having all the requirement of the law for creating a valid charge. This is my finding number 1. Now, second finding which I have given is, if you can move little bit. Therefore, I have concluded that for all the documents has created a valid security interest, because if there is a valid charge as per the SURFACE, it has a valid security interest. So for enforcement of a charge, you should have a valid security interest. So what I concluded in my finding is that since it is a valid charge, they have a proper security interest on the asset of the company. Now, similarly, third finding, if you see, so chronologically you have defined it. Now, I have taken a definition of SURFACE security interest from the SURFACE Act, right? So this is you have to mention that what is a security interest. Now, clause number 4, exit a CDR. So even there was a CDR mechanism also which was attached, where the lender had the borrower had an opportunity to exit from the CDR, right? But that was not much had very legal sanctity on this charge issue. So now if you see, because this was important excerpt, therefore this arrangement of exit of CDR will not have any legal sanctity on this document, because this could be also one of the defense may be taken by borrower.
Yes.
Now if you move next. So now if you see, we have presumed that from between 2010 to 2016, except the documents mentioned above, there are no other documents, right? Secondly, the amount of loan outstanding with IDBI consortium, right, is still outstanding on the date on which the JPL executed the agreement, right? So it was not so that that the loan was fulfilled and there was no outstanding. Even on the date of execution of that document, the loan was outstanding because the company was under insolvency, right? Lastly, the loan upon secured by IDBI was 580 crores, having a charge on the book assets and all the stocks, right? So this was the outstanding amount which was there. Therefore, hence the veracity of the charges can be checked from the financial of the companies, and ROC search shall be helpful in clarifying the case of charge created in addition to the charges registered with SURSI. So this is what we have opined with. It can be seen that Sri agreement in absence of reference of any, because the subsequent document which has been created by Sri had not had any reference of the earlier document which was executed by the borrower with other lenders, right? Because normally if there is any subsequent agreement, then it has to be a reference of the earlier document. Otherwise, it would amount to the suppression of the earlier documents, right? Therefore, the intention of the subsequent document is again a doubtful. So this is how we have to interpret. Now, if you can move to clause number 12. So there may be a defense by the Sri may take a defense that I was not aware about the earlier documents, right? Because he may say that borrower has, while executing this document, borrower was not informed me, or I have not, in my due diligence which I carried out, I did not find any other earlier lending transactions, right? This may be a defense. then what we have concluded, considering the hypothesis, just this was important. 1 second. Yes, just below. थोड़ा सा नहीं ऊपर clause number 12. हाँ बस please stop. So clause considering if the hypothecation deed executed by ADBI consortium, that is document A, B is registered with ROC, SERSI. That means that document is a public document as per section 74 of the Evidence Act, right? And thereby such document is considered as admissible piece of evidence under section 65B of the Indian Evidence Act. So as I earlier said, that if a document is registered, right, it becomes a public document within section 74. And it is considered as an admissible piece of evidence. So since earlier document is duly registered, it is an admissible piece of evidence as per the section 65B. Therefore, considering the doctrine of priority as defined under section 48 of the transfer of, once the document is registered, then any subsequent document, purchase of rights, title, interest over the properties have no protection as per section 41 of the transfer. So this is the doctrine of priority says, if my document is duly registered prior in time, right, and it is properly admissible, then subsequent document which has been executed for any transfer of rights or title will not have any protection as per section 41, right? Therefore, earlier document will have the first right compared to the subsequent. So this is how we, yes. Now, if you stop for a moment here, now another defense would be that I was not aware in my due diligence, right? Then what, to counter that defense also we have stated, the date of registration of the registered documents is deemed as within the knowledge from the date of registration as per Article 61B of the Limitation Act. So this is very important. If there is a public document and it is a registered document as per Article 61B of the limit, it is deemed that it was within your knowledge. So tomorrow I cannot take a defense that that I was not aware about the earlier public document, because as per Article 61, it is very clear that if there is an earlier document, it is duly registered and it is a public document, it is deemed to be within. Therefore, tomorrow Shri cannot take a defense in their plea that I was not aware about this public document. It is deemed to be in knowledge. This is the effect of law. Now, so this defense also we have ruled out in our opinion. Now, suppose if the document meets the criteria as per section 10 of the Indian contract, then such document can be considered as a void document as per section 23. Therefore, any document which is created to nullify the effect of law could be considered as a void document. So there are numerous judgments on this effect. Suppose I created a document to nullify the effect of earlier enforcement of document, then my document would be a void document. Therefore, as I earlier said, that the intention of document is very important. Suppose, therefore, the document E, which was executed by the borrower in 2016, is created to nullify the effect of the earlier lending documents, right? Therefore, as per section 23, I can say that the subsequent document which is executed by JPL is a void document because it is created with an intention to defraud or to nullify my earlier lending agreements. Now, kindly see my conclusions. So now I'm giving my conclusion. So I am first framing a query. What is the legal validity and sanctity of the Shri document in compared to with other legal agreements? So I have stated that document is a public document, therefore admissible piece of evidence. Second, I have stated that they are duly registered. Therefore, since they are registered, it is deemed to be knowledge for public at large. So tomorrow I cannot say that since it was not within my knowledge. Third, I have stated in my conclusion, if you can just move. So considering the above legal position of law, it has a proper charge, proper security interest, and it is a prior point of time. So considering a doctrine of priority also, right? All the earlier documents is a valid enforceable document, right? Compared to the Shri document. Now their other query would be, what would be the fate of other creditors whose book days were assigned earlier? So it is clear from the above opinion is limited to IDBA concession agreement, vis-a-vis Shri agreement, and hence the fate of other lenders shall be subject to their finance agreement, right? So this is how we have posed the second query. Now third query which we have posed, if same is not within authority, what legal recourse can be resorted under the appropriate statute, including but not limited to insolvency and bankruptcy and the contract act. So this is the third query, that what would be the other legal consequences. Yes. So So from the above, it is clear that recourse for the bankers under approach level, for instance, IDBI have rights under SURFACE and under the RDBI Act. So based on that document, IDBI can approach DRT also and can take action under the SURFACE apart from going to insolvency. So since the insolvency is for the resolution of company and not for recovery, right? So if lender is taking recourse under the insolvency, their intention cannot be for the purpose of recovery. They have to go for the resolution. So this is the judgment also we have quoted, right? Now, third point is in the books, banks decide to recover under Section 52. So there is an option under the Insolvency Act, Section 52, that the lenders can also opt out from the insolvency and then take a recourse under the applicable law for enforcement that security under the SURFACE or DFI, right? So this is the third legal option we are given. So here, see, so these are the opinion based on the lenders, whether they have to take a recourse under the insolvency, SURFACE or the IDBI, and whether based on the document which has been created by the borrower in later point of time, they want to make sure whether this document in future, if they resort to any legal enforcement of their document, whether this would create a hurdle or not. So this is how the opinion has been created. So we have tried to give 360 approach, and we have tried to all the legal informatives we try to incorporate, so that from the opinion it is very clear that the subsequent document will not have any legal complexity, and the lenders can go ahead based on their proper charge. They can take whatever recourse under the law we have suggested. So this is how legal opinion has to be drafted. So now can we continue with our legal? Now you actually asked for share purchase agreement also, right?
Yeah, just
So,
a brief on share purchase agreement, because
yeah,
lot of
so I can just briefly throw a light, because in tomorrow's session I can also request Nipun to throw a broader light on share purchase or share subscription agreement. Now, normally what happens that in many startup companies, if you see Ola or any founder, many investors would come and invest in your startup, right? So they want that once if I invest amount, if there is any FDI also for it, then what their basic thing is that they may want maximum holding and the management on the charge of the company, right? So once I invest in my startup, they want maximum holding from the shares. So whether if they want to buy the share, there would be a share purchase agreement will be executed. And if suppose you have to issue new shares to them, then there will be it will also called share subscription agreement, right? So this is how the share agreement will be executed based on their investment and whatever. Because what happens if I am an investor, if I dip money in your company, my interest would be that I'll put a stringent condition so that I can have a maximum management control in my boards, right? So I can nominate major my board of directors, and even the founder who is, for example, Ola or any startup you take up, the founder will have will be go in minority, because as the company valuation will go up and the investor will fuse the money, they will have a major shareholding by executing such type of share purchase or subscription agreement, right? Now, if you see one more important aspect which I want to share as a legal complexity, whenever you execute any share purchase agreement or share subscription agreement, always make it a point to make it a part of your article of association, right? So when any agreement which you create by share purchase agreement has to be incorporated in article of association. Why I'm saying this? If you have this share purchase agreement as a part of your article of association, then the legal interpretation is that it is a deemed binding effect on all the shareholders of the company. Since article of association is a very important document, it is a contract between the shareholders and it is a binding effect. But if it is a not part of your AOA, that means that agreement may not have a binding on the third party shareholder. So there are case laws to that effect, that if it is a not part of your AOA, that is our article of association, then any share agreement which I have executed between two shareholders will not binding on the third shareholder. So third shareholder may take a plea that this arrangement is not binding on me, right? So this is a very legal important aspect we should keep in mind. Suppose if you are doing from as a investor point of view, you should always make it a part of it, because in many startup dispute we have come across that they have a share purchase agreement, but it is not part of here, so other shareholder dispute it, right? And operation mismanagement cases are being filed, and this is how the entire business has been disrupted. right? And because I have very limited time, tomorrow I'll also tell Nipun to
Yeah.
tell you examples of big startup of Ola and Flipkart, that how they have developed their business from this share purchase and subscription agreement. Because I have said from the litigation point of view, because my job is to find a flaw in the litigation, whereas legal strategy will be the Nipun is the best thing to decide.
Yeah, thanks
So
Nikunji, for joining.
So still we have time. Can we take up question and answers?
Yeah,
So
can
that
we? Yeah, just see the questions, sir. I think most of questions you have already covered in your
so
presentation.
if you can take up question and then I will answer it.
Yeah, just Vijay Kalamchella is asking, dear sir, agreements are documents without registration enforceable by law. He's asking question. What is the major difference in litigation part if it is registered or not registered?
See, as I said, if it is a registered document, it is a legally enforceable document. But if it is not a registered document, your legal enforceability will be doubtful by the court of law. That is, but if it is mandatory requirement as per Registration Act, then you have no choice. But in many cases, for example, in Gujarat, it is not required that agreement to sell is required to be registered. But if you go to Maharashtra, the agreement is sale is compulsory to be registered. So this is the difference. So if a file a suit for specific compromise in Gujarat, if it is not a registered document, but yes, if it is not registered, then also you can cure that defect, and based on that curing the defect, you can file a suit and you can take a recourse under law.
Yeah, the most of questions are there on partnership form only, sir. I think you elaborately explained on a partnership form concept. And whether memorandum of understanding in a family agreement is legally enforceable. Whether the same can be subsequently registered by referring memorandum of understanding previously made.
Yes, because now in COVID times we know that our life is very uncertain. So many business family, they want to secure their future by making a proper family agreement so that the legal heir may not avoid a future dispute, right? Because big industrialized family will have a issue of dispute between the parties. So now this is all very in the pandemic. So yes, family settlement agreement can be made properly between the parties, and partition of the property can be done, right? So all your asset, including movable or immovable asset, or your business can be made a part of family arrangement, and about all the legal heirs, because that will depend on your family testament, whether you are Hindu or you are under any other personal law, because there are Hindu Succession Act is there. Then again,
Yes.
for Muslim, there are other personal laws. So you need to be well versed with the personal laws, and then you can have a family settlement agreement drafted, and that document could be properly registered with the sub-register office, and that document could be future enforced. Now, on that document, you can also file a partition suit, right? So suppose you have a family settlement agreement, and after that, if there is a dispute, right, I can go for a civil suit and file a partition suit, and I can enforce that agreement for the part of my asset, which is there in my favor.
Yeah, Vishalji, next is because of the digital and cyber environment. People are asking about digital signature is also equally valid like a document.
Yes, digital signature is valid because it is a part of the requirement under the law. So everything which is part of the record, it is a valid signature, right? So it is an electronic record, so it is valid.
Just same one, sir. In case of WhatsApp chat, is it evidence in the court of law?
Yes. So that is a very important question, because now we come across.
That's what a lot of people, clients are asking, sir. The
Yeah.
person has to pay me the 5,000 rupee, 5 lakh
So-
rupee. The WhatsApp communication is there.
So yes. So normally, what because I also practice on criminal side also. So if you see, I'll just share a knowledge that WhatsApp is having a server one in India, right? So there is a
Okay.
server in Delhi,
Hmm.
and there is another server which is outside India, right? So any company is always maintaining a server within the periphery of India, right? So now if you have any WhatsApp chat, right, it is regarded as an evidence under Section 65B of the Evidence Act, but you have to give a certificate that whatever chat history, or you can say the transcript, because we put it as a transcript, whatever the conversation as a form of transcript, and that transcript we actually put on affidavit saying that whatever the chat history we putting on as an evidence, certifying it as per Section 16 is a valid, and we have not tampered it, right? And normally court can also, suppose in the criminal investigation you found that you are tampered with the evidence, then from that server at Delhi, the police can also investigate, and they can also get a history from the server side, so that they can also compare whether the history is proper or not, right? So this is how you can corroborate the evidence.
So it's a valid evidence.
Yes, even the recording is also a valid evidence. Suppose if
it's
you have
like-
a phone recording, then again that is also valid evidence, because that phone record you have to produce as a transcript, whatever the conversation between, suppose there is a conversation between me and Nipun, right? And Nipun has threatened me, right? And I was a phone recording. So I will produce, or suppose if Nipun has agreed something and thereafter he is back off. So that conversation is also a valid evidence unless I am able to prove it. So what will be the how to prove it? I'll produce that recording before a court of law, and that recording will be sent to FSL, that is Forensic Science Laboratory, and by voice spectrography, there is a voice spectrography method is there, where the specimen of Nipun and mine will be taken, right? And through voice spectrography, a report will be prepared by FSL and will be produced before a court of law, right? That yes, that conversation having a valid conversation, right? So this is how evidence will come on record. So you
So
have to
now
be
we
very
should
careful.
be very careful about WhatsApp chats and phone calls. So nowadays, almost all phones are getting recorded, and the facility is also available in mobile phones. So we should be.
But if you have an iPhone, then there is a software where WhatsApp call can also be recorded. so you have to be careful. If it is an iPhone, then because then it is not, because iPhone uses a different OS, right? So there is a software that WhatsApp call can also be decrypted and it can be recorded.
Oh, very dangerous.
Because I am myself an IT graduate. Therefore, I have dealt with cyber cases also. Therefore, I am well versed with that aspect also.
Wonderful. Sir, one more question here is WhatsApp chat in IBC, is it acknowledgement of a debt, sir? Can we consider as acknowledgement debt in the court of law? For example, I said.
Nipun is more expert in IBC than me.
Yeah,
but IBC, why? Because I said in the tribunal there is a nature of proceedings is summary in nature. So there is no stage of evidence, right? Because NCLT has no power to take a evidence on record and to examine the witnesses, right? So they have very limited scope of inquiry. So in summary nature proceedings, court will not go into that aspect. Yes, but that again will depend on the adjudication. If other party will not dispute it, right? And if he's acknowledging, so something, whatever it is written, it is acknowledgement of debt. Then, but unless if someone is disputing it, right? Then the issue will arise whether that NCLT will come into, because if you see the NCLT rules, we have one such similar cases where in the defense, one person has produced a forged document and he has produced a forged signature in his defense, right? So we have taken out an application under section, I think rule 43 of the NCLT rules, which empowers the tribunal to refer such document to FSL. So we have invoked that rule, but whether it will go into that level or not under the IBC, we are not sure. But if it will happen, then it will be a landmark judgment in summary proceeding. And so under section 424 of the Companies Act, if you see, the tribunal is empowered with the power of civil court. Therefore, they can exercise power in case as a civil court. But to what extent inquiry is having their own prerogative. But yes, if you have nothing, you can produce it subject to adjudication.
Yes, sir. Yes, sir. Sir, can a board meeting notice can be sent through the WhatsApp?
Yeah. Now there is a Delhi High Court judgment also, which says that you can serve anything on WhatsApp, but unless other party will not dispute, right? So whatever you serve it, you have to produce it. So now we serve many things in High Court also. We serve petition and everything to WhatsApp also, and it is valid.
Yeah, a little bit explanation about witness role and responsibilities. One line, sir, two line, because a lot of 3-4 questions are there on witness. Whether is need to know entire agreement or need to say, testify his signature. I think almost 6-7 questions are there on witness.
Yeah.
2-3 minutes.
So why, as I said, why witnesses are important? Because witnesses means that when they sign a document as a witness, they are well versed with all the facts, transactions of that document, right? So that is only the important bit. Otherwise, by only signing, if they cannot depose in your favor or they cannot testify your facts, then the importance of witness is of no use. That is the reason it is deemed to be that whosoever witness you take into consideration. Now tomorrow, if I go for a marriage, right, even I have to support it by one witness. And tomorrow, if my witness will say that no, I don't identify Vishal, then my marriage will be disputed, right? So witness means that he's having knowledge of entire facts and transaction, including the signature and affirmation of the person. That is the reason normally what I advise my client, that you put a photograph, right? Photograph should be duly signed, half on the this paper and half on the photograph. Along with the signature, you can also have a thumb impression, because tomorrow if any dispute arises, thumb impression cannot be disputed, because if it is go to FSL, right, it will be 100% proved. Signature, you can take a defense that signature may have a different probability. So this is how you can bind document. These are some very good ways to have a proper documentation.
I think Chairman,
Yes,
they
sir.
were also asking whether a witness only signs on the, what about the other pages? That is what one of the queries was asking.
Yes, that's also is there. And regarding a promissory note, require one or two witnesses, either one or a two. That's also is there.
As per Evidence Act, minimum one witness should be there in support of your facts, right? And what other said? What is the other question?
No, sir.
Witness normally signs on the last page. So
Yes.
why not? Should we take on each and every page so that he cannot deny that he does not know the contents? That is what the querist is asking.
Yeah, very important query. There, if you see the pages of petition, normally we see all the pages are signed by the deponent. So it is always advisable that, because sometimes what happens that some pages may, when there is a dispute, I may flip some pages, right? So it is always advisable that all the pages, you can prepare a box, right, below the some space may be given, and in that box it is always advisable that all the pages has to be duly signed by all the parties, including witnesses also, so that page can also not be tampered.
So next one is regarding the dissolution of partnership form, sir. Whether dissolution of a registered partnership deed necessarily wind up through cancellation of a registration only, or else whether signature of all partners on dissolution deed sufficient for the purpose.
The dissolution of partnership will have a depend upon the Partnership Act, right?
Okay.
So you have to take a recourse. So whatever document you executed, if any requirement is not fulfilled under any act, for example, a Partnership Act, then it will not have any applicability. So that will have to refer the relevant act for that effect.
So most of the questions on partnership form, sir. Bonu, sir, do you have any questions?
Somebody was asking about Chairman. I think there is one question here which may require some.
Before that, sir, phone recording you are saying it's valid as per this thing, no, sir. But is it valid without taking a permission? Because I'm recording without your permission. Is it not violation of our law?
See, that will be a violation of privacy by the other person. You are right. But what happens? Suppose if there is a dispute. Suppose if I am getting a threatening calls, right? How I will prove it? So see, it is my right to assert and my right? But if I am using for some illegal purpose, for example, if I have recorded something, and if I am circulating, and if I am defending other privacy, so that will depend on how you are using it. Suppose you are using for any bad purpose and you are violating other rights, then obviously it is an offense. But if you are using it for your defense, right? Suppose Nipun has threatened me and I have recorded it, then it is a criminal offense. So I can say I am not using for any bad purpose, because he has committed something and I am trying to prove in my support. So
Chairman, sir, that one question they are asking is, will MOU entered between shareholders regarding remuneration be binding on the company, or as such, or should it be part of articles of association?
Yes.
See, that is what for any binding effect, I have clearly stated that it has to be part of AOA, because once it is a part of AOA, it is a contractual obligation. It is binding on all. But if it is not part of AOA, then there can be a difference of adjudication.
Yeah, one more question, sir. It's almost 2-3 people asked about this. What is the difference between partnership form with registered with register form or registered with sub-register? So there are register forms and sub-register registrations.
According to my knowledge, partnership form is not required compulsory to be registered, and there are register of forms is there, wherein you can have a form, and you can have under the old Partnership Act, you have to get your partnership registered and you will get a certificate of registration, right? So I think there is a register of form which is like ROC. There is a register of form which is maintained a record for the registration of firms.
Yeah, one more question, sir. Whether partnership dissolution date requires the registration, if partner is allotted an immovable property. In the dissolution, you got an immovable property. The dissolution date is required registration.
Nowadays it is required. Earlier days it was not. I think the learned speaker should be.
Yes, so it is again depend upon the relevant act that it is required to be registered or not. So whenever any transfer of right or title you undertake under the specific law, you have to meet that requirement. If it is not meet, then it is a defective transaction.
Yeah.
So this is how.
Yes, sir. One more question in the similar lines, because already 4 partners are there. 1 crore rupee worth of immovable property registered in the partnership firm, and now 3 partners are leaving. 1 more partner is admitting, and three partners are leaving in the partner for what do you say, retiring from the partnership firm, and 1 new partner is admitting. Can we do any registration of this deed in register forms, sub-register?
See, if a property is part of a partnership firm, for example,
registered in partnership firm,
it is a ownership of the firm, right? So
yes.
as for the old partnership, the rights and liabilities are in equal sharing, right? It is not like LLP is a different aspect, new form of registry. So if anything is going out and taking a share, so that will depend on the deed, that what is the percentage of firm, because for 50-50 there is equal liability on the partnership. So it will depend on the agreement, right? So this is how it can be given effect upon. If any person is coming as a partner and other person is leaving, so depending on the terms of the deed, they have to act upon. They cannot go beyond the terms of the deed.
No, what the question is, Vishalji, is whether any registration or addendum is required to do in a sub-register office, because the partner immovable property is there, no?
Yes.
3 people are going, 1 person is coming.
Yeah, then you have to file a modified deed, because earlier deed would, suppose if I'm entering new and other is retiring, right? Obviously then the nature of partnership has been changed. There have been new partners. So you have to get a modified and you have to get new register partnership deed. Yes.
So last question. Sir, many sale deeds are executed for the lesser consideration than actual consideration received through proper banking channel by the seller. What is the legal standing of such documents, and what is impact of stamp duty?
Yes, very, very good questions, because I deal in land cases also. Normally, see, if I can sell my property at 1 rupee also, right? So in a sale deed, if I'm selling to Nipun, I can take a construct for 1 rupee. But that is the reason now the government knows this trick. Therefore, they have fixed a price of jantri. Jantri means that there is a minimum stamp duty you have to pay based on the market price which has been assessed by the government. So my stamp duty will depend on the basic price. Therefore, normally what we people do to save the stamp duty, whatever minimum jantri price which has been decided, that is a market price decided by the government of specific area. Upon that, whatever 4-5%, whatever the stamp duty has to be paid. But if I go beyond that, suppose my consideration is above that, then my stamp duty will increase. That is the reason normally we registered sale deed as a minimum market price, that is we call here is a jantri price assessed by the government, so that we have to pay a less stamp duty. But again, if you go for a loan transaction also, if you want to take a loan, then the requirement would be of more higher amount of sale consideration. So that will depend upon you. So they have to pay more duty, but you will get benefited of more, because 80% depend on the sale consideration, the loan amount will be disbursed.
No, sir, I think he's asking whether such a document will be valid. I think
valid, yes.
Yes. It will be valid. Because if I sell for 1 rupee also, I have to pay the same stamp duty which is fixed by the government. Minimum jantri price. So and my document will be valid.
Yes. Yeah, that to government value we are transferring through banking channel. And
yes.
Duty on that. So.
And if you don't pay the stamp duty, then what will happen? Once you register at sub-register office, it will go to the scrutiny in the Inspector General and will impound the document. So your sale deed will not be released. So that is how the document be scrutinized. So therefore, if I go to register my sale deed, it will scrutinized by Inspector General of Stamp. And if he found that there is a sufficient stamp duty, then it will be impounded and your sale deed will not be released. So and they will issue a notice that this is the violation of stamp, you clear it, and then only your sale deed will be hand it over
Yes,
to you.
reporting will be done.
So this is the
Sorry,
process.
one more question. Sorry, because this is also regarding a land. One other plant obtained certified copy of the sale deed from SRO in place of original not traceable. Is it considered as a primary evidence? Because we are taking Xerox, what do you say, duplicate copies or knuckle copies?
Yes, yes, certified copy from sub-register office is a valid public document, and you can consider as a primary evidence, and you
Primary
can
evidence.
take a charge. So normally in many cases, if agreement to sell power of attorney registered with sub-register office, you can do an index search because that document is a registered document and is a public document within your knowledge, right? So in many cases, if you see, after many years, I file a suit and my legal eye will come and after 10, 15 years, will challenge the sale deed, right? That my right was there, and so that is the reason why, as per Article 61, once it is on the day my document registered at the sub-register office, it becomes a public document and it is deemed within the knowledge of public at large. So my period of limitation would start on the date of registration. There are many judgments to that effects, right? So you cannot file even cancellation of sale deed beyond period of 3 years. So unless, yes, then I have to create a ground of fraud. So normally what we say that fraud has been committed with me, because fraud will vitiate everything. So, and for the purpose of limitation, fraud, in the case of fraud, my limitation will start from the date of my knowledge. Therefore, if it is beyond limitation, my plaint would be on the ground of fraud, and I'll file a criminal complaint also, right? So this is how we, as a litigation lawyer, we play such kind of, under the law.
So one question of general interest, sir. Suppose there is a discrepancy between the recital and the schedule of property.
Yes.
Suppose then whether the recitals will prevail or whether the schedule will prevail.
For the purpose of marking the property or identifying the property.
Yes, identifying the property, or say suppose there is a common lane or something, and in the recital it is said that so and so cannot use it, but in the schedule it is just written as only common passage, whereas in the recital it is written clearly that common passage can be used only by A and B and not C. Whereas C says, since it is only common passage, I also have a right. So under such circumstances, what will prevail?
Yes, very good question. Because if you see nowadays, many builders, what they do, they take common terrace rights as their ownership part. And in the sale deed, if you execute it, they will have that clause that this would be of that ownership. But the law says that common, once the plan is cleared before any competent authority, and whatever the places which is emerged as common area is common in all ownerships. So everybody can use it. You cannot have, by incorporating any clause in an agreement, you have a binding ownership on that part. So such clause would be illegal. And if there is a common amenities as per the plan, right, for all the LOTs, right, then you cannot have ownership, and you can challenge that such clause, and such clause also have been challenged. So this is how you can interpret it.
Nipin sir, do you want to add something?
No, sir, I think Vishal Bhai has completely covered. However, some questions regarding which AOA and shareholder agreement, I think I will try to take up it with NCLT rules tomorrow. So it will give better clarity.
The sir is padded up and with full his gloves and all ready for tomorrow's facing the.
Actually, the difference between me and Nipun is a client comes with me after the disputes are created. So once he comes with me, he is also under financial stress and loss. So he PM is less. Whether Nipun is concerned, because big investors come for the strategy purpose before investing. So he has a very good clientele and he charges good fees compared to me. So this is a difference.
Bonus, sir, the remarks, please.
Well, sir, Chairman, sir, the learned speaker, Vishal ji has covered very widely. As his name indicates, Vishal, even he has covered the topic in a very Vishal manner. And I think it's a very difficult task because it's a very vast subject which has so many doubts, theoretical doubts as well as practical doubts, because all of us might had some experience or the other, the way people are asking questions about partnership and all. They're all and the share purchase, they're all out of practical experiences, and they might have faced some difficulties by ignoring certain small things. So this topic has been very well covered, very widely covered, and in a very, very straightforward with a straight bat. He has batted with a straight bat, and I think there no chance for having any doubt. Even the queries were answered in a very clear-cut manner, leaving no doubt to the queries. And we should really thank Vishalji for such a nice presentation. And thanks to the chairman. Of course, official vote of thanks is the secretary's duty. So I will not infringe on his territory. So thank you, Vishalji. Thank you once again.
Thank you.
Yeah, thank you, Banuji. Yeah, Vishal sir, opening batsman, you done an excellent job. And as my Central Council member told, it's your own pitch, made a century on your own pitch. And
Yes, thank you.
Chairman, I don't know how you selected. You selected Vishal.
No, Banu sir, I was his student. I was his student in one more. I was a student in one more webinar actually. That time I really impressed with this thing. Then I immediately called and contacted Nipunji. Almost from last 6 months I'm talking with Nipunji, and finally we could able to get Vishalji today. And sir, it's an excellent presentation, and really it's a lot of not only informative and very knowledgeable, and it shows your command and subject. It shows your expertise and experience on all relevant subjects, particularly in land matters and partnership matters, and particularly in the cyber laws. And I myself has got clarified a lot of doubts by listening to you. And I not.
Chairman is going to use WhatsApp as a tool again.
Thank you, sir.
No, what I suggest, I mean, if you because I got a very limited time, because I have a very good command over the evidence and other aspects, because I am into litigation, and so I would request that if you have a time, so you can have a special session for the evidence and other purpose. So because I am not a very good as far as academic part is, I'm more into a practical aspect. So if you have because evidence part is very important.
Yeah, so, it's really by answering your question, the way you answered the question shows your practical exposure and subjects. Sir. Thank you so much for giving one more opportunity for Hyderabad branch. Sure, the contact for that. And looking forward your continuous support for the members of Hyderabad branch, sir. And as a token of thanks, I'm request you to act as a certificate of appreciation from the Managing Committee of Hyderabad branch. And so this is a small visual certificate of appreciation from Hyderabad branch.
Thank you, sir. Thank you so much.
Thank you so much, and also request you to join for tomorrow's inaugural session. And
yes, sir. Yes, I'll join.
Here Nipunji is going to speak tomorrow on appearance before NCLT and NCLAT, and the Honorable Madan B. Gosavi is the member judicial from Ahmedabad is joining as a chief guest, and the entire architect tomorrow I am going to say, but today also I want to share the members. Architect of this program is Nipunji, and thank you so much. And thank you, Vishal, for joining us and giving.
Thank you.
And over to Secretary.
Mr. Gosavi is also heading the Hyderabad bench also.
Yes, sir.
He's right now, sir, handling 3 benches: Ahmedabad, Indore, and Hyderabad. So it will be actually a pleasure. And just to tell you the background, he was also the judge who had actually adjudicated that Sorabuddin case. So that Mr. Shah and Mr. Modi and all those cases were orders were given by him. So he's not only having good expertise in corporate law, but also criminal law. So it will be actually a pleasure to listen to him tomorrow.
Great, sir. Great, sir. Thank you, Nipunji.
Thank you. And I really enjoyed the session because there was more question and answer. Because normally when a webinar is there, people will not answer because that I don't enjoy it. But today I really enjoyed with all the participants as well as the respected dignitaries also, and it was very great actually.
Almost more than 60 questions you have, sir, and almost all you answered. Thank you.
So now we can, whenever you get a time, we'll have on a criminal session, including 138 check bounce, criminal case, and how we can, from documentary evidence, we can have a civil and criminal.
Sure, sir. You have given a hint. Sure, we'll do it.
Because that I'll enjoy more actually, because I'll go into more aspect in very simplified manner.
Sir, this has been recorded and it is an evidence that you have Need your help, and the consideration would be decided.
Yeah, yes,
In the form of a certificate, so the contract is complete. Appreciation
yes.
certificate.
Yes,
Wonderful.
grateful.
Wonderful. Yeah, really enjoyed session, sir. Thank you, Secretary.
Thank